All right, guys. Hello. What is this? You like to file a motion to continue? Yeah, sorry, denied. So, but yes. Hi, chat. So, you guys were unaware today. The Michelle Chris trial, they had a snow day, so that's why we did not watch it. Haley says this is a Bruce Rivers case. We'll get to that. Kinda not. So, if you guys don't remember, actually, I want to say thanks to everybody here so far. We're going to talk about what's going on with Afroman and his lawsuit that's going on down in Southern Ohio. So you guys know Afroman, because I got high, Colt 45, 2 zigzags. Well, he got raided by the Adams County Sheriff's Department. And as a result of that, he caught them all on the security cameras. The Afroman interview incoming will be fucking awesome, Walter. That would be great. So he caught it all on tape, the security cameras, and he made a rap video about it. And we'll watch that in case you guys don't remember. It was all about will you help me repair my door? Because it shows him they kick in the door of his house. They're then rifling through all of his things. They pocket money. They claim, oh, we were just documenting things. Well, then that money miraculously came back. A lot of issues there. Then after a while, in the music video, there is a deputy who keeps on looking at the lemon pound cake that's sitting in Afroman's kitchen. And, well, especially that guy, that police officer, got a little butthurt. And they cried about this because Afroman was able to sell multiple shirts, all kinds of things relating to these cops who came to his house on a bullshit warrant. They were looking for drugs. Okay, well, he smokes weed. They also claimed they were looking for evidence of kidnapping. Kidnapping who or kidnapping what? It was never made clear, but it doesn't look like they ever found anything. Now, that's part of the issue because police are going to claim, well, it's a search warrant, not a find warrant, so we might not find what we're looking for. But, then they're going to say, but, they just need to look some more. They won't be satisfied till there's nothing left they haven't tried. But that means for Afroman, the search warrant is kind of protected right now. It's not something that's out there. But he can, what's there. So he wants to try to sue for like a 1983 case. He's kind of SOL for now, but that doesn't mean he can't in the future. But yes, Unhung Hero for $2 says, "Oh, I'm gonna come because I got high." I mean, that's a weird way. If you have to do that, if you have to get high to do that, oof, not a good thing. Not a good thing. Like I said, I thought search warrants had to be specific, and they are. They are. They were specific that they were looking for evidence of drug trafficking and also kidnapping. That's pretty straightforward. Those are very concise things. It lists the place to be searched, what's going to be, when and where. And it wasn't that part's not wrong. It's just what did they do to get that search warrant? Ultimately, I think that's really the big story, but I don't think we'll get it. Am I going to go to the Youngstown meetup with Hunley and Gruber? I forgot that. When are they doing that? Because I might, because Youngstown's not that far away. So, but if you guys don't remember, Afroman did this video, and we'll watch it here because it is an oldie but a goodie. Oh, Mumble is not working again. I can't believe it's not. Can't believe it. I can't believe Rumble of all people, A2 Rumble, is not working. That is just it's unfathomable. I mean, how dare Rumble not work? I mean, like, let's be real. Oh, Rumble. That's I don't know. I don't know what to do with you, Rumble. Some days. Oh, Josh is still going? Oh. I got good he gets deer feeder as well tonight. That's great. Why is Rumble not working here? Hold on, guys. I'm trying to fix this. Lily says, what about the fact he took his money? Well, they claim they took it and then they gave it all back and he said, well, you're missing some more. And they're like, oh, we miscounted. Here's the rest of your money. That's how that went. So he got all his money back. Why did they kick his, why did they turn security cameras off? Well, because they're pieces of shit. That's why they did that. It's not illegal. But it does connote that it does lend credence to the idea they are up to no good if they weren't willing to be surveilled. I sound sick. I feel fine. No, I can't go run like 10 miles, but no, I feel fine. I feel fine. I promise. Stephen Cooper for $5. Thank you, Stephen. Is saying, I don't remember, did they find a kidnapping victim in the CD collection? Well, they did check for that. Here. I'm trying to get why is Rumble suck so bad? All right, I think Rumble's reworking again. So for those of you who really want Rumble, I think it's finally working. I got it up and running. So, yeah, Rumble should be up and going at this point now. So, okay, so let's get started with this. So, it's been a couple minutes anyway. What did Afroman's video do? Well, this is the rap song he made in response based off his security camera video. Now, this is from his actual YouTube page here, so we'll just get this going for a minute. I think he'll be happy people are still thinking about his case.
Will you help me repair my gate? Will you help me repair my door?
So yeah, this was a legitimate no-knock raid. Yeah, they hit this house, they kicked the doors in. They did not spare any theatricality. And for those of you guys who aren't aware, this is down in Adams County, Ohio. This is way down on the Ohio River, in between east of Cincinnati.
Find what you was looking for. Will you help me repair my gate and door? Would you like a slice of lemon pound cake?
Okay.
You can take as much as you want.
This is Deputy Sean Cooley. When you guys see the forms and all the complaints, and we already did the complaint. This is the guy at the top, Sean Cooley. This is the biggest of the crybaby bitches. Of all the crybaby bitches in Adams County, this is like the head crybaby bitch. This is Deputy Pound Cake staring at the pound cake. So.
There must be a big mistake. Would you like?
Is he Sean? Or okay, Jeff? How are you doing? Jeff, if I know you're busy working, but if you'd like a link, I'd be happy to send you one, or you just can listen to my dulcet tones while you're in the fun world of maritime shipping. Is he a Sean? Sean or Sean? He's the first one, a phonetic spelling, not the right one. So let's get back to this.
To have a slice of my lemon pound cake. The warrant said narcotics and kidnapping. The warrant said narcotics and kidnapping. Are you kidding? I make my money rapping. Why does the warrant say narcotics? Well, I know narcotics, but why kidnapping?
Oh, I love the fact he's willing to admit, like, okay, I know why they're looking for drugs. I get the drug part, which I think is fucking hilarious. He's like, wait, I know that one. But yes, the kidnapping. Who is he suspected of kidnapping? Is that a very specific crime in Ohio?
Let me ask you something, officer. Any kidnapping victims inside my seat pockets? Are there any kidnapping victims inside my suit pockets? You crooked cops need to stop it. There are no kidnapping victims in my suit pockets. Let me ask you another question. Is there 1,000 pounds of weed in my suit pockets? Is there 1,000 pounds of weed in my suit pockets? You crooked cops need to stop it. There's not 1,000,000 pounds of weed in my suit pockets.
Although to be fair, I bet Affirmative has smoked probably close to 1,000,000 pounds of weed. I bet he would agree.
Ask you something else. Any kidnapping victims inside my CDs? Any kidnapping victims inside my CDs? The Adams County Sheriff Department, you can get these. There are no kidnapping victims in my CDs. How many pounds of weed are inside my CDs? How many pounds of weed are inside my CDs? Adams County Sheriff, you can get these. How many pounds of weed did you find in my CD?
Spoiler alert, they found no weed inside the CDs, nor kidnapping victims.
Why are you?
Now, this is the shitty part here. This is the real, like, the whole thing's fucked up, but this is even the worst part.
You stealing my money? Why are you stealing my money? You represent the law, and it's funny. You're stealing my legal work hard every day. Pay taxes, money.
It was just an accounting error, guys. We got it back.
The sheriff disconnected my cameras. The sheriff disconnected my cameras. The sheriff.
And they did that for safety because we don't know who's watching us, and they might attack us. You mean for like illegally entering someone's property for bullshit reasons, they might fight back. Shocker, I know. So
should be locked up in slammers. The Adams County Sheriff Department disconnected my cameras.
So if you guys haven't seen the rest of it, I mean, I like the song, but I don't like it that much. We're done. We're done. So what all happened? So he made songs. So who's suing who? All the police officers involved in this raid are suing Afroman. He thought there'd be at least one person in his suit pockets. Yeah, and Selwyn says, "I don't think he found any weed at all." Yeah, for the most part, I don't. And Haley says the fact he hasn't moved to digital with his music is amazing. Well, he's old. Old people do old people things. So the cops are suing Afroman. They're suing him for hurt fees. They're suing him because of all of this stuff. And I'm going to bring these up just so you guys can see them. There was the initial complaint. I'm just going to bring this up real quick in case you guys haven't seen it. And the initial complaint is for a couple different things. And so this is the actual case. Like I said, it's down in Adams County, Ohio. And they had a special judge come in. They have a retired judge handling the case. So it's not even the judge who's down there right now. This got filed last year. So we're almost a year. We're almost a year in. But anyway, Sean Cooley, Justin Cooley, Michael Estep, Sean Grooms, Brian Newland, and Lisa Phillips. And they're done by... and this guy here, Robert Klingler, is their attorney. So that's why care of their attorney, because otherwise you have to provide an address. Because I have to, if as a defendant, I have to respond. So they're seeking damages, injunctive relief, and they want a jury demand. And Randall L. Waters, okay? And they're suing Joseph Edgar Foreman, a.k.a. Afroman. All right, and they're also suing Hungry Hustler Records, which, look at the address here. That is Afroman's label. They're suing Unknown Multiple John Does, which is kind of ridiculous there. And they talk about the raid, everything that happened here, but they sue for multiple theories. And they don't like it because they feel like they are being treated poorly. They feel like people in the community are mad at them and treat them poorly for what they did. And it's like, hey, people in the community are treating us like shit because you searched a guy's house for no reason. Like, yeah, imagine that. People will be upset about it. So they're sued for a bunch of theories, unauthorized use of the individual's persona. And the reason why you guys are seeing this is they're listed as causes of action under state law. So it's in the code, the Ohio Revised Code, but these are the actual like torts that exist. The invasion of privacy. And this is a common law claim. An invasion of privacy, which I know I mentioned before, these people are claiming that, we're acting in our individual capacities, not as deputies. Because if they're acting as deputies, they wouldn't be able to sue because they don't get to sue on the job like this. Which I think brings them open to massive liability, because does that mean they, if Afroman were to sue them, they no longer have qualified immunity? Because if they claim they're acting in their individual capacities, do they have legal capacity to do what they're doing? And I think that, I think they would try to claim that they're making these distinctions in different cases. But if I was Afroman, I would look into using that. But that's just me. Invasion of privacy, they were put in a false light. That they had unreasonable publicity given to their private lives. Which, you're a cop. You are the king's man. You decided to bust into a house. Like, imagine that. People might be unhappy with you. This is entirely a First Amendment issue here. They wanted adjunctive relief. They wanted him to stop selling stuff. They wanted him to stop talking about them. They wanted a lot of things out of this case. All right. They wanted all kinds of nonsense here. Well, the case has been going on for a while. As far as things are concerned, we also had some other parties get involved. There was Bruce Rivers, the criminal lawyer. If you guys don't know Bruce Rivers, CLR, he does civil work as well. He was initially getting in on the case and has since withdrawn. But there were a couple things that happened in the meantime, and one of the bigger things was they filed a motion to dismiss. And they filed a motion to dismiss. They were attacking the case on multiple fronts. And this is really the bigger point here. Actually, do you guys need to go through the complaint? Because I know it's been a long time. Show of hands if we need to talk about it. If you guys need me to do it, I'll do it. Juror 13 says, wait. QI swings both ways. Yeah, if you are not if you're an individual, then you don't have qualified immunity. I mean, are you acting in an official capacity or not? And yes, it's not a false light because you're showing surveillance tapes of what they did. You're putting me in a false light. I'm showing you what you literally did. I think this lawsuit is borderline frivolous to me. I think ultimately, I don't think it's in good faith there. Yeah, you guys don't want to end it. Well, Sheep Hunter just wants me to stop. So, yes. Guys saying no. All right. So those are the main parts that they're suing for. There was a motion to dismiss. Why did this not open? Oh, I know why it didn't open. Because YouTube's retarded. Or the internet's retarded. So, Afroman and his attorneys filed a motion to dismiss and strike the complaint. And they filed a pretty nice response. And they used an attorney in town who responded back for him. And they point out this is a lot of First Amendment protected activity here. These police are just upset that they've been pointed out for being pieces of shit. You know, like, yes, people don't like you disabling security cameras. They tried to dismiss for a failure to state a claim upon which relief should be granted. And the alternative, it was stricken for insufficiency and redundancy. So they talk about the procedural background here, but when you get to the standards, can the plaintiff prove any set of facts which would entitle them to relief? And they claim they can't. And ultimately, this is a big First Amendment issue here. This enshrines everybody's right to freedom of speech. And more importantly, this is government protest. This is political speech. You are redressing your grievances against the government. It was personally acted against you. And it's done by sheriff's department employees who are not happy with what somebody said about them. You could argue this is a strategic lawsuit against public participation, but Ohio does not have SLAPP statutes. So that's kind of one of the reasons why you're thinking, is this a SLAPP lawsuit? We don't have it in Ohio. Ohio's got some good things about it, doesn't have some good things about it. And so there's nothing to worry about SLAPP and anti-SLAPP. So they point out, they make the claim that Afroman's statements are opinions, art, and a private accounting of his recollections of a raid on his house. His music and opinions are art. And that any aspect of an individual's persona in connection with an account doesn't constitute a use for which consent is required. Any comparisons of the plaintiffs with fictional characters, and he compared all those people. He started making fun of all of them. He even accused, I think, Lisa Phillips of being a lesbian on top of everything else. But yes, he was making fun of them, making names about all of them, and they're his opinion. The recorded video is a raid of their house. It's a verbatim account of what actually occurred when the search went down. And the statements were made by the defendants are personal opinions. accounting what they watched. He can't be held liable by speech protected by the First Amendment. Therefore, it should be stricken or dismissed. As far as misappropriation, it's all art. Once again, this is art and it's protected by the First Amendment. They keep hammering on this because it's true. Afroman made art. And it's funny. And it's clearly art. And they gave implied consent when they entered his home. They're public employees, number one. And additionally, they're public employees. But when you enter someone's house, you forfeit a lot of rights. Let's say they have you on camera. Like you should, you lose a lot of privacy interest at that point. And consent is a complete defense anyway. Ohio's a one-party consent state is another issue. You don't have to be on notice. And by entering the home as employees of the sheriff's office, they knew they were at risk of being recorded. Once again, they're just being bitch babies. They claim that the false light claim fails because the statements are opinions and not untrue statements. So this is where you get to the idea of, is this false light or defamation? Well, these were merely opinions that are protected by the First Amendment. It can't be held to be untrue. So Ohio recognized the tort of false light back in 2007. Yes, it officially was recognized less than 15 years ago. A little weird to look at it that way, but false light has three elements: that the statement must be untrue, it must be publicized, and the misrepresentation must be serious enough to be offensive to a reasonable person. There's a distinction between false light claims and those made by people with merely hurt feelings clogging the judicial system. So the defendant must have acted with knowledge or disregard as to the falsity of the publicized matter. Well, I think Deputy Pound Cake wanted that pound cake. He's looking at the pound cake. He keeps looking at it. Why is he looking down at the pound cake the whole time? Is he worried it's going to pull a gun out? He also, I forgot about this. He also compared Officer Pound Cake to Peter Griffin. That's not a false statement. Comparing them to fictional characters or works of art is not, none of that's false. Neither is using video of a raid conducted in your home. So, yes, everything so far is what he did. None of it's false. Hubbleson says, but who is he? Who's Afroman? Are you saying, but Bruce Rivers? Bruce Rivers is a criminal lawyer. He does also civil work. He has a channel here on YouTube, Bruce Rivers CLR. So criminal lawyer reacts. Now you guys are telling me to go through it. Well, I'm going through the motion and dismiss. Charlie says this is a defamation case. Oh, yeah. Porcelain Thunder says it's on video. It can't be false. Yeah, that's the big thing here. Yeah, they have a lot of problems with this. Stephen Cooper says a status report on Matthew Harris tomorrow. He's in the Nut Hut. That's where he is, as far as I know. So, would I cover the trial if this ever goes to trial? Well, we'll get to what's going on there. We'll get to that. And I wanted to focus on the response here because the motion to dismiss really shows you how thin all these claims are. The publicity given to private life is insufficient. Well, their private life, they're like, and once again, this brings up the issue. Were you operating as government officials when you did this? Otherwise, it's fucking burglary. And in Ohio, it's aggravated burglary because you use guns. They have not alleged facts that would show these statements were not of a concern to the public. Afroman perceived a violation of his constitutional rights to be secure in his own home. And yeah, the police did a bullshit warrant and they raided his house, so he has a right to be mad. Any statements would be a valid criticism of the sheriff's office or their deputies under the authority of the sheriff's office. And that would have a legitimate concern to the public. I mean, do we not have a right to that information? Well, I'm sure Officer Poundcake would say no, but it's a good thing Officer Poundcake's not in charge. Then, injunctive relief is not an appropriate remedy and cannot bar his First Amendment right to freedom of expression. And that's the big thing here. Their injunctive relief of stop being the bad man. Judge, make that colored fella stop. Well, they're not, the court ain't doing that. And they have the right to say, that's not, the First Amendment is uber alles. The First Amendment and then Article 1, Section 10 of the Ohio State Constitution. Yeah, that's the thing. It's weird in Ohio, our constitutional rights. We don't start with freedom of speech, but we have a bunch of them. We have some pretty based ones too, but go read it if you want to learn, because we have some cool ones. That they're, they also, their personas, they have commercial value. Well, they don't though. The plaintiffs have to claim that their name, voice, signature, photograph, image, likeness, or appearance have commercial value. And how does Deputy Poundcake staring at a pound cake, or the guy pushing the gate open, or the guy stumbling through the door, or that guy shoving money in his pockets, how do they have commercial value? They don't. That's the problem here. And here's the thing. You don't need to be a national celebrity to have a publicity claim, but you have to show you have at least some value of commerce with your identity. It's worth some money. Their personas don't have commercial value. They are employees of the county sheriff's office. So that means they're county employees. And this is funny because, yes, they claim they've suffered humiliation, ridicule, mental distress, embarrassment, and loss of reputation. Well, when you act like fucking jackboots, people are going to get really fucking mad. That's not a commercial value. That's just tough shit. So that is the motion to dismiss that Afroman's attorneys filed. And that's where things had left off. So we got up to this point the last time, like when this had been filed. And this had been filed back in April of last year. So April of 2023. I think we saw it sometime in the spring or summer. Well, there hadn't been a lot of movement until the past couple of months. So the way it started off with the court making a ruling about the motions to strike and the motions to dismiss. And motions to strike are just motions that it's stricken from the record. It's not valid. We're not, the court, it's not responsive. Actually, hold on here. Why is this? All right. Now, this is where we get to the court making its decisions. And this is where I think you guys want to know what's going on. So this was done October 10th. Thank you. So it is a decision and entry denying in part and granting in part. Okay, well, so there's already some good news, but there's going to be some bad news. And as you notice, the court, when it's addressing things and how this is captioned after a while, becomes Sean Cooley et al. So Sean Cooley and everybody else versus Joseph Edgar Foreman, known as Afroman, and everyone else. I don't know why the A is missing there, but here's all the parties that were listed. They got listed like that. And you saw Bruce Rivers appearing pro hoc vice, meaning he is not licensed in Ohio, but he has sought permission to be there as an attorney involved in that. And then a bunch of people also got involved. The ACLU of Ohio, we covered their amicus motion. I forgot about this. We did cover it. The ACLU of Ohio was like, wait, you're going after a rapper because he made a song about you. That's not how this works. So the ACLU of West Virginia filed an amicus. The ACLU Foundation itself, out the big dogs, filed one. A lot of people did. So a lot of people are involved saying, wait, this isn't good. The complaint was filed March 13th. May 10th, there was a amended complaint. And you know what? We covered the amended complaint as well. I remember that because I'm looking at my list of things I downloaded and the amended complaints in there. So there were 5 in the original amended complaint. There are 5 causes of action: the unauthorized use of the individual's persona, misappropriation, false light publicity, unreasonable publicity to lives, and then defamation. Well, that's still not fucking defamation. They talk about the remedies being requested. We don't really need to get that part done. This is just the court kind of catching everybody up. Here's the defendants. We already know that. April 11th, the defendants filed a motion to dismiss. And we also have this one here. There was an amended joint motion to dismiss and strike the plaintiff's responses. June 9th, the plaintiffs, and we have, you know what? Hold on here. Do we have that one too? Yes, we did cover this too. We covered this a while back. In June, they filed a memorandum in support of opposition to the motion to dismiss and amended motion to strike. There were multiple amicus curiae and or memorandas or letters that have been filed. We did not file anything. I can tell you that much, chat. I'm glad you guys did it. We can't see what? What can't you see? The joint motion? Why is this not moving? What? Oh, damn it. Sorry. Okay. Sorry. We'll start here at the top. October 10th, Sean Cooley and Afroman denying in part, granting in part. Sorry, I was reading. I didn't look over. Here's Bruce Rivers appearing pro hoc vice. And the ACLU being involved is actually pretty impressive. Let's start over here. Let's start again, chat. Everything you just read, I know. We're going to start. Oh. See, here's the thing, guys. Doesn't matter how many monitors I have if I'm just focused in on reading it. So, sorry. All I hear is we're mad someone called us out. Yes. And Helplessness says art really does find the artist. And 10K View says, yeah, this is, yes. Embarrassing. How embarrassing. So there were 5 causes of action: the unauthorized use of persona, misappropriation, false light, unreasonable publicity given to private lives, and defamation. This right here, the judge is talking about the remedies being sought. He talks here about the plaintiffs. Here are the defendants. Here is the status of the history of the case up to this point. Things are going on. We did go through this memorandum to strike. I know we covered that because I look in the folder and it's downloaded from summer 2023. So we did cover it. Neither side requested an opportunity to make oral arguments as to the motions to dismiss, which isn't uncommon. They're just saying, we're not going to make oral arguments, Judge. We submitted our briefs, make a decision. That's not an uncommon way of doing it, especially in the civil context. especially in the civil context. Upon consideration of the amended complaint and everything that's in here, the court renders its decision as to the motion to dismiss and strike. So the defense have filed two motions. One is under 12b-6, motion to dismiss, and Rule 12f, a motion to strike. So civil procedure Rule 12b-6, and this is under Ohio law, not federal law, but it's the exact same thing. Ohio, and that's just the way pretty much every state is. They copied the federal rules because when you say a 12b-6 to pretty much any attorney in the country, they know what you're talking about. It's a motion to dismiss for failure to state a claim upon which relief can be granted. It's procedural and it tests the sufficiency of the complaint. It can only be granted unless it appears that beyond doubt from the complaint, the plaintiffs can prove no set of facts entitling them to recovery. The trial court must review only the complaint, and accepting all factual allegations is true and making every reasonable inference in favor of the non-moving party. Now, you guys have heard that language about reasonable inference in favor of the non-moving party. Generally speaking, the way it works when we watch criminal trials, when the defense makes a motion to dismiss, and they talk about, for the state, all the evidence being looked at in light most favorable to the non-moving party. This is the same thing. So you're giving the benefit of the doubt to the plaintiff, saying, all of this, you're going to make every reasonable inference on all the facts. You're accepting all the allegations as true. And every inference you can make, you make in the favor of the police officers, these sheriffs. Everything's going to be made in their favor. And at that point, is there still enough? If there's still not enough, it's done. If it crosses that line, then it survives. That said, the court does not need to presume the truth of legal conclusions that are unsupported by factual allegations. So if they just write in there, Afroman defamed us, that's not enough. They have to make factual allegations. So that's why they'll say, oh, he said this about us, this about us, this about us. And you guys might think, wow, this is kind of done in a weird way. Well, this is a retired judge, so he's a boomer. It's also a block citation, block quoting. I just wish it was all, once again, guys, no justified alignment. But, it's never going to get fixed. Courts may consider written instruments if they're attached to the complaint. So if there were exhibits attached, they can be considered. But they must be clear and unambiguous on their face. The court's not meant to interpret them yet. So if a contract was attached, well, the court's going to say, unless it's clear, I'm not going to interpret it. All right. But there's no issue of that here. There's no issue about written things, no written instruments. It's just they haven't stated a claim upon which relief could be granted. A Civil Rule 12F motion to strike is entirely different in its purpose, and it is. While an insufficient complaint may be subject to a motion to strike, a motion to strike is not intended to be used as a substitute for a motion to dismiss for failure to state a claim upon which relief can be granted. A 12b-6 motion for failure to state a claim is directed to the entire pleading. Motions to strike are based on the insufficiency of a claim that may be used to attack individual claims, which are not dispositive of the entire action. So when you're striking, you're kind of think about it this way. You're pinpointing in and you're taking like a scalpel and you're cutting out the pieces that aren't right. A 12b-6 motion is taking a sword and you're trying to kill the whole thing. But a motion to strike, you're picking out the parts that aren't good. You're picking away at it. You're chopping away. And a 12b-6 is just killing the whole thing as it is. So there are factual allegations. in the amended complaint. And these are the allegations. Afroman, also known as, he's an individual who lives in Adams County, Ohio, and he produces and creates music under the stage name Afroman. Hungry Hustler Records is the business entity, which is a business in Adams County, and is owned and operated by Foreman and markets and sells his music, his videos, his merchandise, and other products. Media Access Incorporated is a Texas corporation in the business of video and music distribution and royalty collection, and is used by Foreman to do that through its distribution of videos and music on behalf of Foreman. Hold on here, guys. Why is this not? Hold on here, guys. Hold on one second. Hold on here one second. So, sorry. It's the royalty and media access has significant contacts with the state of Ohio. Yes, well, because they are in a business relationship with Afroman. The three John Doe defendants each are a business entity doing business, and with their place of business in Adams County. John Doe 1 is owned and operated by Foreman and is used by Foreman to market and sell music, shirts, videos, and other merchandise and other products, including beer, marijuana, and T-shirts. The other John Doe defendants, 2 and 3, apparently Hungry Hustler, and that's the thing. These guys, this was a very sloppy complaint. Are owned and operated by Foreman, are used to market, sell, and merchandise as other products. Which there's no indication those were other entities, so it's really ridiculous. So the story is, on or about August 21st, the police did their raid in 2022. Foreman wasn't home, but his wife was present and watched the search and recorded portions of it. So if you guys notice, some of that was like actual good quality video, and the angles weren't from security cameras. She recorded portions of the search and videos of their faces on her camera phone. The residents had security cameras, and several of them were operating, which recorded the search, which was going on, and recorded the likeness of the officers who were conducting the search. After the search was done, Foreman used portions of the recording to create music videos about the search. The videos portrayed the image, likeness, and distinctive appearance of the officers involved in the search, including the plaintiffs. And this went everywhere. Facebook. I like how it's YouTube is 2 words to this judge. Snapchat, 2 words. And once again, this judge. TikTok. Oh, boomer judges. God love you. God love you. I was trying not to laugh here, but I'm surprised he didn't say Instagram. Instagram. Reviewed by thousands of people. A lot more than thousands. Pretty sure the one Afroman movie or video has like millions of views. The videos have been used by Foreman for commercial purposes to promote his brand and sell products. And that's a funny thing here. The examples of the complaint include Foreman wearing a shirt with an image of plaintiff Sean Cooley, Officer Poundcake, beside an image of Peter Griffin. He also started calling him Officer Poundcake and getting 5.4 million hits on TikTok. So, Congratulations, you're famous for all the wrong reasons. As you can see, all my pound cake is gone. Officer Pound Cake confiscated my pound cake. He said something happened to his body camera on the way to the evidence room. Well, that's a thing. The body cams of these are going to be very interesting. But we're not there yet. So that's actually not true. This guy never said this to him. Afroman's making that up. But yes, and then there's this stuff here. The Instagram post containing fans holding up the merchandise that contains images of Cooley with the caption "Lemon Pound Cake." Another Instagram post where Afroman confirms that OG Afroman, his official account, contains images of Brian Newland, one of the other deputies. And he goes through all of these. He promotes his new album. His new album is called it's Lemon Pound Cake is the name of the album that he made about them. He literally made the whole album with the name Lemon Pound Cake. It was really good. He did another Instagram post. I'm pressing merchandise for my up-and-coming Canada tour. Which Officer Pound Cake shirt do you like the most? The left or the right one? I give him credit. He trolls like a boss. Most of this is about Lemon Pound Cake. And it's really about the first guy, that big fat guy, which, he really bore the brunt of this, but, too bad. He then did Sean Grooms, one of the people in the raid, next to an image of Quasimodo, who is from The Hunchback of Notre Dame. I don't know why, and this isn't the complaint itself, but there's an Instagram post about Judge Gabbert, the judge who signed the search warrant, next to an image of Droopy. I don't know why it matters, because that judge is not listening to this complaint. So, but this is he says, vote out this judge before he signs a warrant, and sends him over reacting paranoid KKK cops to your house, jeopardizing the lives of you and your family, stealing your money, and disconnecting your home security surveillance system. And then he says, vote out the judge, then go get my new album, Lemon Pound Cake, September 30th on all platforms. And then Lisa Phillips, the lady who disconnected the cameras. He called, making fun of her, call her Mona Lisa. The Adams County Sheriff, Lieutenant Lisa Mona, and she calls him Lick 'em Low Lisa. So, yeah. He talks about them stealing the money and other things around your house, even possibly planning false kidnapping evidence. And I assume this is true because there was no denying of it. I used to speak to this lady when I dropped my kids off to school. I was wondering why she never spoke back, just looked at me with the same condescending cunt look you see in the picture. And the lady is a cunt. I do love this, though. I spoke to her at the metal detector at the courthouse, and her voice was 3 octaves lower than mine. Has anybody verified her vagina? And just keep on Lemon Pound Cake. He keeps on pumping it. So they go through all the things that were filed here and all the complaints, and yes, they go through each one of the individual plaintiffs has a thing that was made fun of through this. But they talk about the false statements, and this is where we actually get to what happens and how they're making the actual claims here. So, And according to the false statements, that he claims that they stole his money and were criminals camouflaged by law enforcement. Well, they did take his money, and they had to say, "Oops, I'm sorry. We actually do have it. Sorry about that." He called the cops white supremacists operating inside of the Adams County Sheriff's Department. I think it's an opinion. He stated that one of the officers involved used to do hard drugs, snitched on all of his friends, and now he steals money from traffic stops, bogus raids, and from the Adams County Sheriff's evidence room. Which I'm assuming ultimately, if this ever gets to deposition, I'm sure Afroman is going to be able to prove how he knows this guy used to do hard drugs and snitched on all his friends. That'd be hilarious. He claims they stole his money. Through his Instagram post with words and images that Lisa Phillips is biologically male. And I love how the judge writes, is trans or is a lesbian. Yes. At least the judge didn't say transgender or something. Odin cult? Yeah, the Odin cult did this. Rambo's right. Oy vey, you realize we stole your money. Sorry about that. Alex says, I keep rubbing it in too. Charlie says, I thought you were really joking. It really says, has anyone checked her vagina? Yeah. No, he fucking didn't hold back. These guys fucking deserved every little bit of this. So no, he fucking did not hold back. He went after them, and I think it was more than fair. So Sean says, I'm sure it's a great album. I've heard a couple of the songs on it, and it's actually not it's not as good as Cold 45 and Two Zigzags, but it's pretty good. It's pretty good. So he's more than famous. He's infamous. Yes, he's infamous. Chadwick says, people really give people give Florida a lot of shit, but you Ohio people really need to lay off the drugs and Jerry Springer's shit. Sincerely, the rest of the USA. Hey, Ohio is where Florida Man came from. Florida Man didn't happen on his own. A guy from Ohio came down to Florida, settled down, and set up shop, and he became Florida Man. So don't you get rid of us, you get rid of yourself. Something to think about. Something to think about. We made you. He then stated plans attempted to kill me in front of my kids and came to kill me in front of my children, and that they constituted a hit squad to kill me in front of my kids. So we actually have to. So those are what was set out. The court will now apply the standards to each plaintiff's claims in their amended complaint. And now the court, and when we read this, the court's doing so, it's pointing out it's not assessing the sufficiency of the evidence as each claim, which will be a matter to be ruled on through a subsequent summary judgment motion or trial. So he's not going to rule on everything, but he's going to rule on some stuff. So it's not going to be fully fleshed out, and that's his way of just telling you why. And that's not abnormal. I think that's a fair way to handle it because, what's he? I mean, we are at the summary judgment phase, so he shouldn't be making too many factual determinations at this point. As few as he can make is the goal. So the first one, the unauthorized use of individual persona. God, like a boomer. He's got an orphan down here. He's got a... Widows and orphans, guys. Make sure you fix those when you're using word processors. Don't do those. So... they talk about all the things here. And this talks about revised code 2741.02. So, a person shall not use any aspect of an individual's persona for a commercial purpose during the individual's lifetime. A person may use an individual's persona for a commercial purpose during the individual's lifetime if the person first obtains the written consent to use the individual's persona from a person specified in section 2741.05. A use, and then it goes on, and they point out that under Part D, using an individual's persona in connection with any news, public affairs, sports broadcast, or accounting of a news, public affair, or sports broadcast does not constitute a use for which consent is required under Division A. And that's fair. We don't want the news to have to get bogged down in that, and that would allow people to silence the news, because if it's unfavorable, you could silence them through court action. Persona is their name, voice, signature, photograph, image, likeness, or distinctive appearance, if any of these have commercial value. Notice there's that last little bit, if any of these have commercial value. Commercial purpose, and he doesn't, and that's the thing. If you go back this is the definition statute. And if you guys are ever trying to figure things out in Ohio, the .01 is generally the definition statute for whatever it is you're looking at. Now, it doesn't say commercial value and purpose, but the use or reference to an individual's persona in any of the following matters: in connection with a place, product, merchandise, goods, services, or other commercial activities not expressly exempted. Okay. For advertising, for advertising or soliciting the purchase of products, goods, merchandise, services, or other commercial activities not exempted. For the purpose of promoting travel to a place. For the purpose of fundraising. The pertinent facts that the plaintiffs allege: they are peace officers. Yes, they're police officers who were engaged in a search of Afroman's house. The videos were recorded, and the recording was subsequently publicized along with commentary related to the video. They argue that their likeness was in connection with the place, product, goods, merchandise, services, or other commercial activities not exempted under the revised code. And we saw this. You don't have to have celebrity status to recover. And the difference is, though, they're local law enforcement who they have no value tied to their name or their identity. While they may be well known and unquestionably are public servants who come into contact with the public, that is not sufficient to demonstrate there's any value in associating an item of commerce with any of their identities. And that's fair. To argue Afroman's making money off them, no, it's, did you have any of that at the time? No facts have been suggested. This is a case similar, for example, of what happened with Urban Meyer. He sued somebody for using his likeness and selling merchandise and capitalizing on his name to make money. Yeah, he already had that. It existed. In contrast, it's absent the demonstrating in particular commercial value, which has not been alleged in the complaint. Afroman felt aggrieved by the search warrant and chose to demonstrate his displeasure while at the same time selling his merchandise based on his own celebrity. And that's true. Afroman was already going to sell shirts. He already does concerts. I think if Afroman had not had a job but started rapping and making fun of the cops, then there might be a little bit there. But for these guys, they're not, nobody gives a shit who they are. Nobody cared who they were until they broke into Afroman's house. I'm trying to catch up here. What are you guys saying? Cue up the I hate George Washington gay comments. Name of some sort says it sounds like cope. Yeah. Jim, we're going to get to all that. Just hang tight. We'll cover that in a second. Alpha Fox says West Virginia made Ohio man. I don't know about that. I doubt it. Zaven says insert page break as your friend. Yes. Page breaks are a thing, folks. Yes. Tom says, I wish I had an afro. Well, how are you doing, Tom? Oh. There are a couple other Stephen Cooper for $2 is actually saying there will be a Matthew Harris update tomorrow, according to Pacer. Oh, okay. Yeah, then we'll take a look at it. I thought you were just like jerking around about that, but no, we'll cover it. We'll see how much unbreaded our boy's doing. No, thank you for the update. I appreciate that. And here I was thinking it was just people in chat being people in chat, but you're being a true and honest poster. Quite simply, the court finds there are no facts which have been set forth in the complaint which lend support for a viable claim of unauthorized use of their persona. The plaintiffs have failed to state sufficient factual matter accepted as true to state a claim that to relief that is plausible on its face. After presuming the truth of all material allegations in the complaint and all reasonable inferences therefrom in their favor, it appears beyond doubt the relators can prove no set of facts as to count one warranting relief. So count one. Count one. Right here. Dead. Oh, that wasn't a good X. Gone. Count two, invasion of privacy by misappropriation. And this is, we're going to skip these relisted down here. We're going to get to the actual discussion of it here, okay? A defendant is subject to liability for invasion of privacy under Ohio law when he appropriates his own use or benefit the name or likeness of another, and the name or likeness has commercial value or other value. In this case, the value seems to be the issue here is not the monetary value of the officer's likeness, which appears to be nominal. Instead, the issue appears to be the humiliation and outrage the officers feel at having their likeness displayed and mocked by the defendant. Yes, the judge is realizing these guys have soggy tampons. The black rapper man is making fun of us. No! I'd like to there should be a footnote down here like they're having a Loretta moment. Undoubtedly, they also feel aggrieved by their investigative actions being questioned publicly. In this regard, while the parties might debate the artistic quality of the defendant's videos, music, and commentary, it appears without question they were made as part and in the course of criticism and commentary by Afroman of the search and seizure that occurred at his house. They have a minimal interest in their right of publicity. Certainly, as public servants, they have to expect that they may, from time to time, be subject to commentary and criticism regarding the performance of their duties. And after considering that commentary and criticism, as well as all the facts contained in the complaint, the court finds as a matter of law that while their quality and appropriateness may be questioned, and this is where he's saying, like, look, you might say he's an asshole or it's not nice what he's doing. You can question that, but that's not an action. It's not actionable. The defendant's artistic and musical renderings have substantial and creative content which outweighs any adverse effect on the plaintiffs in terms of their publicity. So he's going to say after balancing these interests, embodying the First Amendment against their property rights, which they really don't have much. The court finds as a matter of law that the effect of limiting plaintiff's right of publicity in this case is negligible and is significantly outweighed by society's interest in the freedom of artistic expression. So the motion to dismiss count 2 is well taken and shall be granted. So count 2, gone. 40% of the way there, chat. If we were talking about genders, we'd be done by now. How many genders are there? Well, we counted to 2, and we'd be done. But we have 3 more claims to get through. Oh, I scrolled too far ahead. I'm sorry. Number 3, the false light publicity. So here we go. The Ohio Supreme Court has recognized publicity that unreasonably places others in a false light before the public as one of the 4 separate branches of a tortious invasion of privacy. And there's requirements for a false light claim. First, the statement that is the basis of the claim must be untrue. Secondly, it must be publicized, which is different than published. Publication is a word of art, which includes any communication by the defendant to a third party. Publicity means the matter is made public, communicating to the public at large so many persons that the matter must be regarded as substantially certain to become one of public knowledge. So it's one thing just publishing it. I tell somebody about it. But publicity, I'm running around the town square screaming about it. Every person I meet, hey, by the way, did you know the police fucked with my house and ate the pound cake that was on my day in my kitchen? That would be publicity. So there is a big difference there. Sociology is trash. Well, yes. Genders aren't real. There's only biological sex. Yes. You guys are trying to build towers. Well, remember, this is Somalia, guys. There are no building permits necessary. So, build everyone. Stacy says, I would totally tell everyone. Yes. And Afroman fucking told everybody. He made a song about it. And he tells everybody about it probably everywhere he goes. The difference is not one of the means of communication, which may be oral, written, or by any other means. It is one of a communication that reaches or is sure to reach the public. That's a big deal. Next, it must be serious enough to be highly offensive to a reasonable person. So, the publicity given to the plaintiff has placed them in a false light before the public of a kind that would be highly offensive to a reasonable person. In other words, it only applies when the defendant knows that the plaintiff is a reasonable man, would be justified in the eyes of the community feeling seriously offended and aggrieved by the publicity. The defendant's privacy is not invaded when the unimportant false statements are made, even when they are made deliberately. It is only when there is such a major misrepresentation of his character, history, activities, or beliefs that serious offense may reasonably be expected to be taken by a reasonable man in his position that there is cause for invasion of privacy. Okay. So, the restatement, guys, and I don't know if we've mentioned this before, but the restatements are a series of law books where law professors and academics from all over the country get together and they do restatements of torts, they do restatements of contracts, they do restatements of a lot of areas of law. And these restatements cover the very big basic issues. Think of it kind of like big common law, like legal dictionaries, I guess, for a specific subject. And I know that, like, and law professors are screaming and probably internally as I say that. That's the best way I can describe it to you guys. You get the restatement of torts, and you'd pull it open, and you'd go through like false light or publicity or invasion of privacy, and you go and you flip through, and this would lay out everything out. And there's all kinds of case law listed in them. I mean, these things are bullet stoppers, and they're multiple volumes. But that's what the restatement is, and there's multiple restatements now. I think everything's like on the second restatement, and there's groups that are trying to like push through the third restatement of like torts and contracts and criminal law and civil law. There's other restatements that are out there too. I forget what all they are off the top of my head. Yes, like restatement of tards. Yes. And Alpha Fox, yes, it's not binding because each state is different. But a court, if it's trying to figure out what's going on, is going to look to that if it doesn't know the answer. Like, what should we do? Well, what does the restatement of torts say? And yes, if you're an attorney trying to make arguments, you might go to that restatement and dip into that well and work on things. That's a shame. Says this is why I quit my grad program in sociology to go to law school. So, Garrett says, speaking of Ohio, are you a fire hose fan? Well, I'm a fan that the firefighters have fire hoses because otherwise it'd be really hard for them to put water on fires. If you mean firehouse subs, I'm like, yeah, they're okay. They're fine. I mean, better than Subway, but it's not saying much. Russell is saying, as in the Fourth Amendment, in what way were you talking about? The restatements? I'm not sure what you mean there. So, Luke is saying it's persuasive, but it's very persuasive. Yes, it is. It's very persuasive. So, we're going to keep going, though, here. The restatement also accounts for multiple claims arising under the same set of facts. This is a restatement of law, second edition torts. And it's literally broken down like this. Section 652D. And then it's got a comment. Then there's 652E. And like, it's if you just start trying to read it, your brain's going to melt because you're going to want to kill yourself. You have to know where you're looking. And you read through the table of contents and find what you need. The interest protected by the section is the interest of the individual in not being made to appear before the public in an objectionable false light or false position, or in other words, than as he is. In many cases in which the rule stated here applies, that the publicity given to the plaintiff is defamatory so that he would have an action for libel or slander. In such a case, the action for invasion of privacy will afford an alternative or additional remedy. So it's an alternative or an additional remedy. And the plaintiff can proceed upon either theory or both, although he can have but one recovery for a single instance of publicity. And that's true. So you could proceed under the defamation road or the false light road, but you can't get double recovery for the same act. So if Afroman said, Lickum Lisa, I saw her, cornholing out somebody with her 8-inch penis, she could say that's defamation, or she could say that's false light. She can't get him on both. Now, if he says a second statement where he says, I watched her fuck a horse. Okay, well, that's a separate statement. So she could get count 1 under defamation, count 2 under false light. She has alternative options there. First, and then we're going to continue on, though. First Amendment concerns are addressed by the following restatement standard, requiring the defendant had knowledge or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the other would be placed. Well, I mean, they are cops, so they are thieves, they are criminals. In construing the complaint against in construing the allegations of the complaint in the plaintiff's favor, as the court must do in considering a motion to dismiss for failure to state a claim for relief, the plaintiffs allege the following. They stole his money and are criminals. They are white supremacists. One plaintiff used hard drugs, steals money from traffic stops and bogus raids, and the sheriff's property room. One plaintiff stole $400 of the money placed in an envelope, which that is debatable. That one where they took Afroman's money and he stuck it in his pocket. Like, oh yeah, we had an accounting error. We found it. Bullshit. One plaintiff is biologically male, trans, or lesbian, and then their intent was to kill him. So the plaintiffs claim all these things are The plaintiff is claiming none of that. They're like, that's not true. They're saying none of it's true. The defendant's alleged to have publicized the things set forth, and it was highly offensive to a reasonable person. They are public figures, but it can reasonably infer the defendants acted in reckless disregard of the truth or falsity of the statements made. The fact that things were said may be defamatory and give rise to a claim for defamation does not affect the validity of the false light claim. So for now, the court says there's a triable issue whether the defendants committed a false light violation, and the claim can go forward at least at this stage in the proceedings. Now, he's not saying they have a valid claim. He's saying for right now, they survived the motion to dismiss. That doesn't mean in the future it won't be another motion to dismiss or a motion for summary judgment. But for right now, that's survived, and we're going to have discovery on that one. At least some discovery. This may not get through the full discovery process. It might come out very quickly. These guys are fucking lying. Who knows? But for right now, there's this lives to fight another day. Count 3 lives on. Unreasonable publicity given to private lives. So they make their claims here. And basically, they're suing under the publicity tort for invasion of privacy. There must meet some elements, though. There must be publicity. The disclosure must be of a public nature and not private. Okay. 2, the facts disclosed must be those concerning the private life of an individual, not their public life. And 3, the matter publicized must be one which would be highly offensive and reasonably objectionable. Would be highly offensive and objectionable to a reasonable person of ordinary sensibilities. Well, we already addressed a bunch of these probably would count, so that one might be. We'll see. The publication must have been made intentionally, not negligently. And 5, the matter publicized must not be a legitimate concern to the public. So they talk about the restatement again. And this is a appellate case here that's citing the restatement. So they talk about when one who gives publicity to a matter concerning the private life of another is subject to liability for the other for invasion of his privacy if the matter publicizes of a kind that would be highly offensive to a reasonable person and is not of legitimate concern to the public. So they talk about that. They have to review the standards. They're going to review the allegations. With these standards in mind and reviewing the plaintiff's allegations as set forth above, the court is unable to say that it appears beyond doubt from the complaint that the plaintiff can prove no set of facts entitling them to recovery under the publicity theory of invasion of privacy. So for right now, this survives. But when you look at it here, he's claiming that it's a lot of the same stuff. It's the same things here. So he considers one of the ladies to be a lesbian or transgender. Well, none of that has to do with her public job. So yeah, there's probably a lot here they're going to be able to use. A lot of these claims are going to get to discovery. So there's going to be depositions. There's going to be fact finding. It's going to be interesting to see what comes out of it. So count 4 is still alive. Count 4 is still good. And then count 5, as PewDiePie says, that's still not defamation. They claim they were defamed. And defamation occurs when a publication contains a false statement made with some degree of fault, reflecting injuriously on a person's reputation or exposing a person to public hatred, contempt, ridicule, shame, or disgrace, or affecting a person adversely in their trade, business, or profession. So to show a claim for defamation, a plaintiff must show a false statement of fact was made. The statement was defamatory. The statement was published, and the plaintiff suffered injuries approximate result of the publication, and the defendant acted with the requisite degree of fault in publishing the statement. So we already talked about the issue between publication, and publication is just saying it to a third party. So any communication by the defendant to a third party. We've already talked about that. A statement's defamatory if it reflects injuriously on a person's reputation. Okay. We already just addressed all of that. But then we get to the New York Times v. Sullivan, because that's the standard we're dealing with. We're dealing with Afroman, who's a public figure, and then the police officers. Well, we have the higher standard, actual malice, as it applies to public officials against critics of their official conduct. So they're held to the actual malice standard. They have to prove actual malice. This prohibits a public official from recovering any damages for a defamatory falsehood unless he proves the communication was made with knowledge or that it was false or with reckless disregard of whether it was false or not. The determination of whether a party is private or public is a matter of law. This includes the determination of whether a party is a limited purpose public figure. Police officers acting within their scope are public officials under Ohio's libel law, and therefore only enjoy limited protection from public discussion and criticism of their performance as officials. Accordingly, the officers in this case are classified as public officials for purpose of defamation. Statements made about public officials are constitutionally protected when the statements concern anything that may touch on their official fitness for office. The abuse of a patrolman's office can have great potentiality for social harm. Hence, public discussion and public criticism directed towards performance of that office cannot constitutionally be inhibited by the threat of prosecution under libel law. And by prosecution, I mean like public, like a private, like a lawsuit. But it's true. A police officer abusing his power in his office is very dangerous. They also point out a public official may not recover under damages for a defamatory falsehood relating to their conduct unless they prove that the statement was made with actual malice. Knowledge that was false or reckless disregard. And the proof must be clear and convincing. The defendants argue that every statement by them was a statement of opinion, and that gets, that's not fact. Opinions are not facts, and under the First Amendment are protected. The defendants are correct that expressions of opinion are generally accorded absolute immunity from liability under the First Amendment. In this regard, to be defamatory, a statement must be a statement of fact and not of opinion. The defendants claim there's no evidence of any false statement made by them. In contrast, the plaintiffs claim that the claim was stealing money, that they tried to kill him, that they threatened to kill him in front of his children, that they were sent as a hit squad for the purpose of killing Afroman, that the plaintiffs are white supremacists, and that the plaintiffs are criminals. And then specifically for individual people, that the one officer used to do hard drugs, was a snitch, and that he steals money from traffic stops, raids, and then he stole $400 from the evidence room. That Lisa Phillips is not a female and is trans or lesbian. Yeah, they point out like those are defamatory to us. Now, in determining whether the statement is actionable as defamation, the court must consider the totality of the circumstances to ascertain whether a statement is opinion or fact. It involves 4 factors. First is the specific language used. Second is whether the statement is verifiable. And third is the general context. And fourth, finally, is the broader context in which the statement appeared. So, let me stop here and see where. In my resume says those were facts too. Yeah, well, they are true. The cops are fucking criminals, so. And they're crooks. Let's see here. Just making sure I didn't miss anything. So we're going to keep going here, guys. Whether certain statements alleged to be defamatory or actionable or not is a matter for the court to decide as a matter of law. Specifically, the determination of whether an averred defamatory statement constitutes opinion or fact is a question of law, properly within the court's purview. They must review the totality of the circumstances, consider the statement within its context, within its context, and determine whether a reasonable person would interpret that statement as defamatory. This is very difficult on a motion to dismiss. Many of the statements referred by the plaintiffs appear to exactly that, statements and not opinions. Well, I disagree. But the court is saying because it can't tell, it has to give them the benefit of the doubt. The court cannot conclude as a matter of law at this point from the proceeding that the statements made by the defendants were not made with actual malice. Furthermore, the court cannot find beyond doubt from the complaint that the plaintiff can prove no set of facts entitling to recovery as to count 5. So they are still in the game. They have the right to, provide facts that show they can get recovery. But will they? So count 5. Count 5 gets a big old check mark because it's court doesn't know yet whether or not it's defamation. And then count 6, the injunctive relief. An injunction is a remedy. It's not a cause of action or a claim for relief. So, the court will consider the plaintiff's request for injunctive relief if and when the plaintiffs prevail on one or more of counts 1 through 5. So they could get an injunction later, but for right now, he's not going to grant that. So at any time, counsel may brief and argue the authority and appropriateness of the court ordering injunctive relief in the manner requested. So it's always something that can be brought up, but for right now, we're not dealing with it. So this, gone. We're not talking about it no more. We're not talking, they're not talking about Bruno today. And it's a summary of it here. So counts 1 and 2 are beyond doubt from the complaint. They can prove no set of facts, and they are dismissed. The judgment is dismissal is entered as those counts. For counts 3, 4, and 5, it's unable to find that the plaintiffs can prove no set of facts entitling them to recovery. So they're going to get a chance to fight another day on these 3 counts, but only these 3 counts. The other 2 are gone. So that is it from the judge here. And this is what he ordered. So there's some good points to it, but this is probably going to go to discovery at this point. I don't see Afroman settling, and neither should he, because I don't think ultimately these guys are going to claim how much have they really suffered. And I don't think there's a way for them to quantify that to a reasonable level. So they can say that, oh, this all happened to us, but there's nothing there. Oh, the community doesn't like me. Well, how do you know the community doesn't fucking hate cops? It's Adams County, Ohio, so it's not like, it's Southern Ohio, and yeah, they it's good old boy country down there. They're not exactly fans of the law. They're gonna have to show damages, yes. And I don't know whether they're gonna be able to do that. So that is going to be their issue. So, and I forgot to mention this. I don't think we went through what got filed in October after all of this, but Afroman did file a counterclaim. So they filed a answer and a counterclaim. So remember, when you and that's the neat part about civil law, when you file an answer, when you file a complaint, the other side can file an answer, and then they can file a counterclaim saying, you did wrong, and then they can file a counterclaim saying, no, you did wrong. And now they, it's, bullets crossing. So this is obviously days afterwards. So it's the 27th, and they responded. And I have not read this one, and I I'm actually curious to see what this says. So we're gonna learn together, chat. And actually, hold on one second. All right. So the answer in counterclaim. So once again, Sean Cooley and Joseph Edgar Foreman, aka Afroman, they submit their answer in counterclaim in response to this. This is actually a great way to answer it. You deny each and every allegation, fact, matter, thing contained in plaintiff's amended and supplemental complaint, except herein specifically admitted, qualified, or otherwise pled. So they might admit some things like Afroman lives in Adams County, Ohio. Okay, yeah, I admit that. Because if you deny that, well, no, it's true, and you know it's true. They address some issues they think are vague. They admit that number 17 with the qualification, they don't believe the search warrant was lawfully issued. They deny that. They deny everything, and they deny everything with an additional facts written out in here. And this is not uncommon to say, we deny paragraph 26 of the complaint. And then you elaborate on it further. But you can also just say, we deny paragraph 22. You don't have to elaborate further, but sometimes you do want to elaborate further. So they point out to count one, the defendants repeat their denials and admissions and all the answers they gave before. They deny everything except that the plaintiffs are cops in Ohio. They go through all of this. They deny everything that's here. And the thing is, they already filed the motion to dismiss, but they have to formally deny everything now because these have survived. And notice we're on the count, we have the counts here that are a little different. So they have to answer, they're answering to all the counts, okay? And one thing here, where is... And some of you might say, well, wait, they already got a dismissal. Why are they answering some of these? Well, some of this was already ready to go. They were probably hoping they didn't have to submit this. But once the court shot them down, they had to submit it. So notice that they already are talking about these two things here, the misappropriation and unauthorized use of the persona. Well, those already got tossed, but it all gets denied. They're just going to deny those things anyway. So we got false light publicity. We already know the court allowed this to survive. We already know the publicity given to private lives. And then the defamation. That's still there. And the injunctive relief, yeah, this is in a holding pattern. But we already know the court said this is good. This is good for now. And then this is good for now. That doesn't mean they'll stay that way, just for right now. But yes, they completely deny. They repeat all their denials, and then they deny all the paragraphs there. They completely deny, and then they deny all the paragraphs there. Everything we said before, we're meaning now, and that's also including these things here. And we're also denying all their stuff. This is a similar one. We're denying all the stuff here. In response to the demand for judgment, they're saying, nope, you guys are full of shit. So now they talk about affirmative defenses. Okay, well, failure to state a claim upon which relief can be granted. They say it again, as to all counts, failure to state a claim which upon relief can be granted. They point out the claims are barred, which are factual in nature, cannot form the basis of the claims amended in the supplemental complaint. They're saying these aren't based on facts which could be adjudicated. As far as all these statements about him making these claims, they're barred because Afroman believed they were true at the time of making them. Well, that's a fair. Remember, it's always a valid defense to defamation and false light. I thought they were true. They claim that these are barred because his statements bear substantial truth and they're therefore not defamatory. Well, I hope you have some proof this guy, or people who could say, yeah, this guy stole money from me at a traffic stop, or he's alleged to have taken it out of this evidence room, because some of these statements are going to be a little rough for Afroman at the end of the day. And I would hate to see, one of these kind of scumbag deputies get money out of him and be like, ha ha ha, I took him down. I got a settlement in court. That his statements are fair comment and criticism of the execution of their police duties. That the claims by the plaintiff are barred because they were pure opinions and not factual statements. They talk about the opinion privilege. They also point out that the First Amendment of the U.S. Constitution is protecting him. That their claims are barred in part based upon self-publication. These are barred because there's no articulable damages. He tried to get it thrown out because they amended their complaint, which the court, they didn't amend the complaint. It wasn't good, but the court allowed it to stay in. And that this is frivolous conduct and sanctionable under Rule 11 of the Higher Revised Code. So it's just like the Rule 11 you hear other attorneys talk about. It's the good harbor provision. You're going to say to the attorneys, like, look, you guys need to withdraw this. I'll give you a chance before I crush you. So, plaintiffs are barred by the doctrines of unclean hands that they've come here and they've caused the issues. That they are not the good guys either. That is the unclean hands. If you seek equity, you can't come in with, you being the fault as well. The idea of estoppel. Why? God damn it! Why is this? Why did not I put it up here? I tried to share the screen. I clicked on it again. I thought you guys could see the screen here. Fuck me running. Goddamn StreamYard, you fucking piece of shit. You fucking click on it and it doesn't fucking work. All right. So we'll start up here again. This is their response in the counterclaim, the answer in counterclaims. They deny all the allegations unless they make a specific point. So they admit a couple of the basic things. Yeah, he lives in Adams County, Ohio, and that they're police officers. If they point out something's vague or they're unsure of something, they'll say this is vague and we're unsure of what they're referring to. They'll admit with a qualification they don't believe the search warrant was lawfully issued. Sometimes they'll just flat out deny, which you're allowed to do. Notice this came out 2 weeks later, after the dismissal judgment. But this was already typed up and ready to go, so they just threw it all in there. And there's nothing wrong with readdressing these issues. The court killed this one already, but you know what? You're going to respond to it. You already have it there. The court killed this one, but you're going to respond to it. But he's going to talk about the false light. We completely deny. Publicity given to private lives, completely deny. Defamation, completely deny. The injunction, fuck you guys. We're not talking about it. And then the response for a judgment, completely deny. They talk about failure stated claim upon reliefs can be granted. Okay, yeah, this meets the 12B6 motion. They're still asserting it because you have to assert it now. If you don't assert them at the time of your answer, you waive bringing them up again in the future, absent leave of parties. And the parties may, or the court may allow you to do it, but you're barred if you don't raise them now. So Afroman thought his statements were true, that there was substantial truth and they're not defamatory. His statements are fair comment and criticism, that he gave pure opinions and not factual statements. And the First Amendment protects him, that he is based on self-publication. They have no damages, and that's a big one. I think it's going to be a very big problem. They have no damages. Because how do you know these people didn't already fucking hate the police in that community? And that this frivolous conduct and is sanctionable by Rule 11. The doctrine of unclean hands, and this is where we stopped. Is it still working for you guys? Because I clicked on it again. I'm trying to make sure it's stuck there. Is it still working? It's Schrodinger's court document. Yeah, I get it. I get it. Oh, but it's the problem with StreamYard. You click on things. Yes, view the tab, and it won't do it. It's also the principle of estoppel. Now, estoppel is a traditional affirmative defense, and unclean hands is an affirmative defense. Is estoppel applicable here? Well, not necessarily. Estoppel is like where you promise somebody you're not going to act. Okay. Well, like let's say, and I doubt this happened here, but let's say Officer Poundcake told Afroman, like, "Hey, man, I'm not gonna sue you. It's okay." Well, now there's detriment. Like that's an estoppel. It's a promise. You made a promise not to do it. You've said you're not going to do something. You're kind of bound by that in civil court. Did that happen here? No, but you state all the affirmative defenses anyway because you don't know which ones may come up. All right? These are contrary to public policy. That is a very common affirmative defense. We don't want the police suing the targets of search warrants because they got caught doing something wrong. The police should have to grin and bear it. They should have to take it like the bitches they are. That they can't show by clear and convincing evidence that any of the statements were made with actual malice. That one's going to be a little weak in this case, but they can make the defense there. The defendant asserts herein all applicable defenses set forth in the Ohio Rules of Civil Procedure to the extent they're not specifically stated. They're claiming to reserve the right to assert defenses as discovery continues. And they reserve the right to seek attorney's fees for the frivolous claims pursuant to Civil Rule 11. And that's there. They are making the claims there. And if you guys want to know what the other... There are other defenses that they can raise. And they say that, well, we're not going to list them all, which... Does this work when you say, like, I'm going to do all the... Is this work? I mean, it kind of works, but it's probably not the best way to do it. You generally wouldn't want to list them all out, and you can do like latches, and like we talked about this Robert Barnes and the latches. It's like, oh, you waited too long, you sat on your rights. Anything else you might want to put together there, you can do, but this is what the Supreme Court of Ohio, this is the Rules of Civil Procedure. These are all the options you have for affirmative defenses here. I took a second to find it, but there's a ton of them, and some of these don't apply, but you'll assert everything just in case, because I don't know what we're going to need. A party shall set forth affirmatively accord and satisfaction, like arbitration. We already did arbitration. Assumption of the risk. I could argue assumption of the risk that if you're a public official running in there, but that's more of a negligence issue. Like if somebody gets killed or injured, they assume the risk when they got hurt. Contributory negligence, that's not going to apply here. Discharge of bankruptcy, that doesn't work here. Duress, not going to work here. Estoppel can work here. Failure of consideration, that's a contract issue. Want of consideration for a negotiable instrument. Well, once again, that's for a negotiable instrument like a check or a bond or some sort of commercial paper. That's not applicable here. Fraud, I don't think that's here. Illegality, what they're trying to force was illegal. Injury by a fellow servant, that's not one here. Latches is one. There's no licensure issues. Payment, well, we actually did pay. Release, they signed a release waiving us. Res judicata, that this has already been litigated before. You can't bring it up again. The statute of frauds. Statute of frauds are for specific things that must be reduced to writing Otherwise, they're not enforceable. The statute of limitations, well, we're well within that. Waiver, they've waived it. They've signed off saying we're not doing that. On any other matter constituting an avoidance or affirmative defense. And this is the part, and you're like, well, what happens if I mess it up? Well, when a party is mistakenly designated a defense as a counterclaim or a counterclaim as a defense, the court of justice so requires shall treat the pleadings as if there had been a proper designation. So if you mess up, the courts can kind of like read into that. But these are all the affirmative. There's other ones out there, but these are like the ones you may ever run into, or they're common to run into. There's a lot of them. You guys want to read what these are? Some of them are actually interesting. So servants, no, you can't fix them. Most things reduce rank. Fuck you. I'm not doing this right now. Contracts for land, something that can't be done the performance can't be done in less than a year. If it takes longer than a year, you have to have it in writing. You're supposed to have it in writing. There's multiple things for the statute of frauds. So I just thought it'd be helpful for you guys to see what actually they're talking about, all the other things that are out there. So what is getting back to this, the counterclaim, and this is interesting because we didn't get to this yet. And I haven't read this. Like I said, I read these along with you guys brand new because I think it's a little more interesting that way. So there's a counterclaim. So Affirman saying, no, you. It's the reverse card. So they talk about the search warrant was provided in the home Exhibit A, and we will be able to look at that. The search warrant was based on false information provided by Mr. Foreman's. This is interesting. Mr. Foreman's alleged personal assistant, which is listed as confidential informant number 1. He must, and that's the thing I will tell you guys. When criminal stuff happens, I can normally go to somebody and I'll, walk up to you and say, hey, do you know who they're talking about in the search warrant? And a lot of times they'll have an idea because the person gives away specific information, like, oh, I know that's so-and-so. So they must know some information there. Okay. While part of the search warrant is redacted, it appears that confidential informant number 1 was likely arrested for possession of 2,131 grams of cannabis. That's a felony in Ohio. At the time, that was illegal. You couldn't have that. That's trafficking in marijuana. That's a lot of grams. That's a lot of grams. That's all the grams. But, to be fair for Afroman, that's probably that's like Wednesday morning for me. I'm sure, but that is a lot of weed. That's a whole kilo of weed. Two keys is a lot. That's 1 key. Well, actually, it's 2 keys. Yeah, it's 2,000 grams and a kilogram. 2.1 kilograms. Yep. Yeah, 2 kilograms is like 5 pounds. Yeah. Hubbleson says it's not that much. Well, I mean, for the average weed smoker, that's a lot of weed. For Afroman, I don't know how much it is. There are 35 ounces in 1 kilogram. Yep. And a kilogram is 2.2 pounds. So CI number 1 made several false allegations saying that Mr. Foreman has a large amount of cash and that he was holding women hostage in a dungeon. Okay. So the officers raided Mr. Foreman's house. They wielded assault-style weapons during the raid. Now, that's the thing. You guys may not like this, but when you do it for effect, like I've done this before, the police raided the defendant's home using high-powered weapons leveled at his children. You go ahead and do that. The body cam footage shows the front door of the house was knocked off its hinges, and we saw that. It was laying on the floor. The cops also appeared to have damaged the second door. It shows the officers looking through all of his belongings, including his rooms, closets, bed, vents, trash sheds, vehicles, and other spaces on the property. He was forced to repair a security system after the officer ripped the DVR off the wall and disconnected all the wiring. Yeah, good job, Lickum Lisa. Law enforcement did not find evidence of drug trafficking or kidnapping while at his house. He has not been charged. He still has not been charged to this day, even now in 2024. While returning Mr. Foreman's money, an employee of the Adams County Sheriff's Office admitted that the money they were returning to Foreman was $400 short of the money that was taken from the house. This statement may or may not have been captured on camera. So they're $400 short. So it sounds like somebody stole some fucking money. I mean, they admitted it was short, and it sounds like it was recorded. The plaintiffs in this case are all Sheriff's Office employees. Therefore, they have qualified immunity to civil actions subject to exceptions in the rule of the qualified immunity statute. And Ohio has its own qualified immunity statute. Just like there's federal qualified immunity, Ohio has its own qualified immunity, which they shouldn't have. Law enforcement officers do not have qualified immunity if the act or omission was manifestly outside the scope of their employment or official responsibilities, the act was of malicious purpose, in bad faith, or in a reckless manner, and liability for the act or omission is expressly imposed in a section of the revised code. Here they're saying the plaintiffs acted with malicious purpose, in bad faith, or in a wanton or reckless disregard for manner when they raided the home. The confidential informant used to gain the search warrant was unreliable, and yet the officers relied on the informant's allegations. It appears the CI was incentivized to provide information after being arrested for possessing cannabis. Yeah. They probably said, give us something or we're going to give you a felony. So I'm sure he talked and saved his ass, because that's how it goes. The only information provided by the CI was corroborated was the informant's description of the exterior of the house. The plaintiff's actions constitute conduct outside the scope of qualified immunity and deprive the defendant of their civil rights as secured under the U.S. Constitution through 42 U.S.C. 1983. Well, you guys who watch John Bryan, the civil rights attorney, that's his bread and butter right there. As a direct or proximate result of the plaintiff's wrongful conduct, the defendant sustains a serious damage and a violation of their rights. As a result, there are several counterclaims. Conversion by destruction and alteration of property. Now, conversion means not that you took it in like the door is not trans. The door has been converted. It's been altered. I converted it from a door that works to a door that's broken. I convert your window pane from a solid sheet of glass into multiple pieces of glass, and now your window doesn't work anymore. I've altered it. I've altered the door. The door no longer works. I've damaged it in a way that it's no longer normal. When they talk about the plaintiffs engaged in the wrongful act of conversion when they improperly took and maintained possession of Afroman's house and possessions over which they had no legal right to conduct a raid. And conversion is also when you take something. So they converted the property. So like when they took things, they converted the money, they converted any of the CDs, anything they fucked with is been converted or altered. They further committed the tort of conversion by destruction and alteration when they damaged the doors, door frames, and trim to the house. They committed this tort with malicious purpose, in bad faith, or in a reckless manner. The police have not paid for the replacements to his door, and he has suffered damages because of the conversion. It's a direct and proximate cause of their conversion. Afroman sustained injuries, damages, and a violation of their rights. Now, the injuries doesn't mean physical. It can mean economic. It can mean any number of injuries. Injuries to his property. But he doesn't actually have to be hurt. Hubbleson says, oh, it's a portal now. Yes, I'm sure that's going to work. So Michael Boyle says, is calling Lisa a lesbian actually considered defamation in the current year? Yeah, I mean, it's not only that, but he was claiming she doesn't have a vagina. Is she a man? She talks in 3 octaves lower than Afroman. So there's some issues there that might be a problem. Now, it's Southern Ohio, so it's not like this is being done in Los Angeles County where, you know, like a judge in LA would read this a lot differently and be very upset at Afroman if, you know, making fun of somebody being trans. This is in Southern Ohio, so it's going to be a little different. It's going to play a little different. So, yes, Hubbleson says it's all that weed was 2.13 million milligrams. That's great. I'm glad. Thank God for the metric system, I guess. 10K View says his parody was a way to recoup the losses. Yeah. Yep. I'm sure he's gonna say, "Why'd you make this?" Like, because you guys broke all my shit and I had to pay for it. Composer C says the weed. Yes, the pot needles. So as a remedy, they want monetary damages and other remedies. Count 2 is conversion by destruction and alteration of property in the closet. So they talk about when they damaged the closet during the raid. Notice they talk about the door trim and all the things here. The doors, door frames, and trim. Now what they did in the closet. So malicious purpose and bad faith or in a wanton reckless manner. They damaged his closet. Okay, well, they haven't paid for the repairs to his closet. Notice this isn't as well, like, there's not a lot of factual support here. So that might get dismissed unless they, you know, that's an issue for them. But here, this is pretty, you know, what they did when they came in. There's a little more to it. It's a direct and proximate result of their conversion. Count 3, conversion by destruction and alteration of property, the security cameras. And yeah, security cameras were altered when they disconnected and damaged the cameras in the DVR during the raid. That was done maliciously in bad faith or a wanton and reckless manner. Mr. Foreman had to hire somebody to get a new system in a DVR. They haven't paid for the repairs, and he suffered damages. And it's a direct approximate cause, and he's entitled to monetary damages. Trespass to chattels. Okay. Chattels means it's chattels, not cattles. Chattels. Chattels are your property. So when you hear the term chattel slavery, that means where people were treated like property. It's slavery where people are treated like property. Okay. So, oh God, well, they explain it. Trespass to chattel occurs when one intentionally disposes another of their personal property. And that's what the trespass means. Like, how can I trespass? You know, you could trespass my chattels. You could trespass all over this chattel. You know, your chattel can bring all the boys of the yard. But how do you trespass over that? Well, you're dispossessing me of my personal property, and that's personal property. It's not real property. I mean, yes, in the philosophical sense, that highlighter was real, but it's personal property. It may be committed intentionally, dispossessing me of the chattel, or intermeddling with the chattel in the possession of another. So if you're fucking around with somebody else using my highlighter, well, you're now trespassing on the chattel still. They intentionally dispossessed Foreman of his security cameras during the raid and caused damage because they aren't working anymore. So they've been converted. They're cameras now that don't work. Okay. Well, now they've also trespassed his chattels. A camera that doesn't work is worthless. You may as well not have them. They don't have to take them. It's if you destroy or obstruct or fuck with somebody's things, you're now trespassing chattels as well. So Russell says, who gets cute about cannabis before the treason charges? Alpha Fox says, "Oh, they use an expert witness in OB-GYN." Yeah. That, you know what? That's the funny thing though, because when you make medical claims like she is a woman, she's contesting the fact that she's a woman. Prove it. Go. We're gonna hire an OB-GYN. We have the right to bring in a doctor to examine her. So I mean, that would be very dangerous at that point if they were to, like, unless they had proof she wasn't a woman, like making that lady hop up in the stirrups and having a gynecologist come in and like testify like, yes, I examined Lieutenant Lisa Phillips in depth, and I can confirm she's a woman. I got the speculum all the way up in that bus. Like, that would be a very bad idea. That's not going to work. So, 10K view says, "I'll lead the trespassing of chattel to rackets." Zero Buck says, "Cattle can be chattel. 100% cattle can be chattel." Yes, all cattle are chattel, but not all chattel are cattle. So, yes, what is a woman? She might be considered chattel. Maybe we have to repeal the 19th. So, so he had to hire somebody to repair the security system, get a new DVR. Notice a lot of this is redone. You're kind of like spitting these back out, but it's because, just like we talked about with the false light and defamation, you could pursue multiple theories, but you're only entitled to one recovery because they didn't destroy 2 sets of security cameras. They destroyed 1 set. And this way, it's, if we can't get them on option A, we try option B. And you notice a lot of this, some of this copy and pasta, it's just, and that's part of writing a civil complaint, is a lot of copy and pasting. And then you've got to reread through it and make sure it all works right. So, yes, the intentional conduct of damage interfered with his right to use his, and access and use of private property rights. So, conversion, and this is another type of conversion when you take something, and that conversion was the $400 that they have not returned. That $400 is still there. The plaintiffs claim there was a counting mistake and they don't have the $400. He's repeatedly requested his $400 back. The plaintiffs haven't returned the $400, and he has suffered because of the converting it. Shoving all that in their pockets probably wasn't a good look, and that's not going to be a good look when this gets somewhere, because it never gets in front of a jury. And like I said, most cases don't ever get to a jury, just like Gina Carano probably never go into a jury within a million miles of a jury. But we'll get some discovery there. This is definitely going to get some discovery. Okay. As a direct and proximate result of the conversion, he's lost $400, and here's the thing. Your monetary damages, you're only allowed to request back what you lost in this situation right here, the $400. Okay. So I want monetary damages. You get back what the money they took. You don't get to get, like, I want $75 million. There's another counterclaim, trespass to chattels. Remember, chattels is personal property. Well, money in your pocket is personal property. A dollar bill is personal property. So it's for the $400 of U.S. currency. And notice, just like the plaintiffs, they're using the restatement of torts. And this is their way of saying, like, this shit's legit. So a trespass to chattel occurs when one dispossesses another personal property. In this case, his $400 is missing. And we know that because the $400 is missing. They claim it's a counting mistake and they don't have it, which I'm saying, you know what? I don't believe you. There's another counterclaim. So all this, guys, we already went through all this. Went through it 15 times in a row. We're going to skip that. Frivolous conduct under the revised code. This is the frivolous actions here. The claims in the complaint have no basis in law. The claim's true purposes are to squelch Mr. Foreman's artistic freedoms and freedom of expression because it's unflattering to the plaintiffs. It merely serves to harass or maliciously injure Mr. Foreman. On the other defendants, it is improper for another purpose. And that's true. This is their warning. This is their way of saying this is bullshit. You know it. You better fucking stop. That's what's going on here. So now remember, we talked about this. Ohio doesn't have like slap, anti-slap. We don't have any of that. So it's not really. You know, we don't have any like. I mean, this is a strategic lawsuit against public participation. But we don't have anti-slap. So, and a court's not like, you're not going to convince a court all of a sudden to say, yes, I agree, we should have anti-slap laws. This has to be put together by the Ohio legislature. Or the Supreme Court of Ohio may do it, but some judge out in, Hee Hawville, which is where this is going to happen, isn't doing it. The claims in the complaint are not warranted under existing law, cannot be supported by a good faith argument for an extension, modification, or reversal of existing law, and cannot be supported by good faith arguments for the establishment of new law. So they talk about here with Rule 11 in Ohio, the Ohio Civil Rule 11 says, every pleading or motion must be signed, and it's that the attorney's parties acknowledge information. There's belief for good grounds to support it, and is not interposed for delay. Okay. This complaint was made in violation of Rule 11. There's no good ground to support the claim in the complaint and the request for injunction and or monetary damages. Filing the complaint, the verification of the complaint, constitutes frivolous conduct because it's not true. This is all bullshit. Each of the foregoing is sanctionable under revised code, and the defendants are entitled to reasonable attorney's fees. Yes. So anybody who's helped sign those forms or any of that crap out there, those attorneys are on the hook for it. So it's not, anybody else, if they hired more attorneys or other people who were involved, yeah, it's not good. They also bring up another counterclaim, illegal search and seizure. They talk about signing the search warrant and the application used to gain the warrant for the home. The search warrant contained allegations from a confidential informant that appears to have been arrested for the possession of a large amount of cannabis. Yep. The publicly available portion of the search warrant, it appears the vast majority of the informant's allegations were uncorroborated and improbable. Afroman's been the subject of unwarranted attention since he's lived there. The actions leading up to the application for the warrant and after the raid show personal animosity. Allegations in the search warrant are so improbable that Mr. Newland should have known they were false or misleading. Plaintiffs, and they talk about all this here, but this is the interesting part here. Mr. Foreman's had his house broken into on multiple occasions. One break-in was likely perpetrated by a person mentioned in the search warrant application. It does not appear that Adams County has investigated any of these break-ins, but did feel it was necessary to raid his home on the basis of unreliable information. They're also bringing up 42 U.S.C. 1983. And they're citing that. They're bringing it up that, yes, they're violating our rights at state law and through federal law. Now, they also bring up count 9, First Amendment retaliation. All the other paragraphs are fully restated here. That he produced music videos about the raid. The complaint has 6 causes of action. 2 of these causes have already been dismissed. And the cause of action for an injunction is invalid. As the court correctly stated, injunction is a remedy, not a tort. The plaintiff's complaint appears to be written in haste and insufficiently alleges facts to prove the alleged cause of actions, and neglects to give sufficient justifications for any of the damages caused by the plaintiffs. It's hard to believe they didn't know that his speech was protected by the First Amendment under the U.S. Constitution and the Ohio Constitution. But remember, what do cops get to do under qualified immunity? They get to go, we just simple police folk. We don't know no better. We just dumb old police, man. Oh, Lord and Massa, be nice to us. That's what the cops are going to say. The purpose of the plaintiff's lawsuit appears to squelch Mr. Foreman's freedom of speech and opinions, and it's analogous to a SLAPP lawsuit cited in the amici briefs. Yeah, it's a SLAPP. It's a strategic lawsuit against public participation. There is no anti-SLAPP statute, though, like I said, so Afroman's kind of boned. If there was an anti-SLAPP law, he could come in and nuke this already. But it's glad to see that they are addressing this as a SLAPP lawsuit. And once again, his civil rights have been deprived under 42 U.S.C. 1983. Abuse of process is the next, once again, guys, we already covered this stuff. Direct approximate cause, sustained injuries, damage, and the remedy, monetary damages, injunctive relief, and other remedies. So we've already done that. I heard oink. Yeah. Saban says, can the government entity be labeled a vexatious litigant? I guess theoretically they could, but I don't think that would ever happen. Remember, the government watches the government's back. So Stevie says, bitch better have my money. Yeah, they better have that $400. Zaman says it's interesting how Afroman can state specific damages in his counterclaim, but the shitbag police can't. Yeah, it's interesting. So it's very interesting. Allegan News for $4.99. Thank you. It's saying Lemon Pound Cake is a better song than the first one. Did they add this to their complaint? Oh. No, I don't think that's in here, but we'll find out pretty quick. Well, you guys are talking in Spanish for. I'm completely lost. So abuse of process is a separate tort action. They improperly used a search warrant in legal proceedings for a malicious or perverse reason for which the proceedings were not intended. And this goes back to the idea they probably have some sort of beef with him. It was done with ulterior motive, malicious purpose, or in bad faith, or in a reckless manner when they raided the home. So there's approximate cause. The damages, 14 U.S.C. 1983. I said 42 U.S.C. 1983, direct approximate cause. And they want remedy. So all this stuff, again, we've already covered. We're covering this again. Remember, this is a lot of copy pasta. That's normal. Count 11, tortious interference in business relationships and contracts. So as much as Eric July was talking about tortious interference, I have a feeling this is actually tortious interference here. So they filed this lawsuit against the defendants producing music videos using footage of the raid. Mr. Foreman is an entertainer, and Hungry Hustler Records is his record label. Maybe he'll sign me on his label. His primary source of income is his occupation and vocation as an entertainer and artiste. They committed this tort malicious purpose in bad faith or in a reckless manner to disrupt his career and Hungry Hustler's business relationship with venues and other vendors. He's lost several business opportunities as a result of the raid on his home, the initial coverage of the raid, and this lawsuit. This is translated into lost earnings. Venues had decided not to host him as a performer as a result of the raid on his home. I'm sure they have emails and correspondence stating that. Tortious interference has deprived him of his civil rights as secured by the United States Constitution and 42 U.S.C. 1983. This tort was committed in malicious purpose, bad faith, and a reckless manner. Direct approximate cause. And they want monetary damages and injunctive relief. So they demand judgment against them as follows: that the plaintiffs take nothing by the 3 remaining counts of their action, that their amended complaint be dismissed with prejudice. On counterclaim number 1, against all plaintiffs jointly and severally, for an award for actual damages in the amount of $1,500 for damaging Mr. Foreman's doors, door frames, and surrounding trim, for punitive or exemplary damages, and for attorney's fees, costs, and expenses of litigation. For count 2, jointly and severally, so he doesn't care who pays or they all pay, doesn't matter, an award for damages of $1,000 for damaging the closet, punitive damages or exemplary damages, and for attorney's fees, costs, and expenses. Okay. Count 3, against all plaintiffs jointly or severally, an award for $6,000 for damaging the security cameras and DVR and the required repairs. Once again, for the same types of damages and attorney's fees. Count 4, another $6,000. Remember, these are, done in the alternatives, conversion and trespass. So that's why we have it. It's the same thing again. Boom, 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 boom. Count 5, it's for the $400. Count 4, it's for the $400. Count 5, count 6. Count 7 is an award for a reasonable attorney's fees because of this frivolous lawsuit. Count 8, for the illegal search and seizure, an amount of damages in excess of $25,000. Now notice, there's no limit on that, in excess of $25,000, because in Ohio, that is the floor for getting you into common pleas court. It's the amount of in excess of $25,000. You have to state that if you want damages in excess like that, okay? That's why it's listed that way. And they want a fees and cost of litigation. Count 9, against all plaintiffs, they want in excess of $25,000 for raiding the house and filing this frivolous lawsuit as retaliation. Count 10, an award for actual damages in excess of $25,000 for abuse of process and using civil legal proceedings for a malicious or perverse reason. Count 11, another in excess of $25,000 for the lost earnings, for the interfering in business relationships. That the defendant be awarded costs and disbursements of any such other relief as the court deems just or equitable, saying, Judge, hey, if you come up with something, we would like it. If you think about it and you come up with it, we want you to apply that too. Tack on all that good shit. Now, why is that important? Well, if you don't list it, the judge may say, well, you didn't bring it up, I can't award it. That an injunction be enforced against the plaintiffs and joining them from filing another lawsuit against defendants for engaging in conduct protected by the First Amendment of the U.S. Constitution and the Ohio Constitution. I think that's fair. I think that's totally fair. Get an injunction against these guys from doing this again. That's what should happen. That is 100% what should happen. There's no other reason why this case is going on except these cops are little bitches. Haley's saying, Judge, throw me a $5. Yes. Garrett says, I want muted merch. I tried to do it, and Teespring keeps taking it down, saying that other people have trademarked for muted, but not in the same style I've done. So I don't know what the problem is. I might have to go with someone else in a minute. So, yeah. These fools probably thought they were so cool going in Afroman's house. No, because they probably didn't realize it. They probably thought they were going to be, we're going to get him for sure. He's Afroman. He smokes weed all the time. It's going to be like Raid Snoop Dogg. It's going to just be weed everywhere. I'm sure that's what they thought. I'm sure they totally thought that was going to happen. I don't doubt it at all. Also, they're cops, so they're not necessarily bright. They probably thought, oh my God, there's going to be girls in the basement. We're going to be saviors. We're going to be rescuing women in trafficking. So, So that is what we need to get to now. Here are the exhibits. So the certificate of service. Yeah. Now, all these parties that filed an amicus brief, they get served with, things because you do that just out of courtesy there. And their parties, even though they're amicus, they still. And it was respectfully also submitted by Bruce Rivers, the Rivers Law Firm. So this is this is from the judge, okay? So this is the judge who signed it. Exhibit A. Has been filed before me an affidavit demonstrating probable cause for a search to be made of, and then Afroman's house, 1299 Russellville Road, Winchester, Adams County, Ohio. And this is where you describe with particularity where it is you're going. So, okay, we're going to the address. Well, what is it? A single-family, 2-story home with white siding, green shutters, and a green metal roof. Okay, so there's particularity here. With a covered front porch and a gravel driveway having a large white metal pole, barn-style structure with a green metal roof on the north side, and a wooden fence surrounding the property and being the current residence of Afroman. To include all outbuilding storage containers, curtilage, vehicles, and or persons located on the property. Namely, they're looking for evidence of included but unknown qualities of marijuana, marijuana derivatives, any and all other drugs of abuse, drug paraphernalia, scales, packaging materials, and paraphernalia used for the sale and administration of said drugs, money obtained from the sale of illegal drugs, and documentation regarding the sale of illegal drugs, as well as weapons used for the protection of the above. Also, which are crimes which are considered in violation of revised code, possessing drugs, trafficking in drugs, and then kidnapping. But notice they don't include the provision for kidnapping, but that is a crime in Ohio. You are commanded by any reasonable means necessary to do it, and you are to search during the daytime or nighttime. So they were given nighttime access. This is a no-knock raid. You have to, in a warrant application, you ask for a nighttime or the ability to enter at night under the cover of darkness, because it's drug dealers and dangerousness. And they had 3 days from the issuance of the order to do it. Property you found, seize it, leave a copy of the warrant and receipt for the property taken, and prepare a written inventory of the property seized, and return this warrant to the clerk of courts. So there was a return likely done on this. We're just never going to be able to see it. Now, this is part of the affidavit, but we don't have the whole affidavit. Okay? Because you notice here, we're missing some pages. So this starts off with there's generally a search warrant has an affidavit. So it's talking about the affiant. If you're writing the search warrant, you don't say I. You speak as you're the affiant. So we don't have the beginning of the search warrant. Wherever that was going to be here, it's gone. We don't get it. So it was the drugs that were caught by the CI were 2,100 grams. Being more than 1,000 grams but less than 5,000 grams, it's a felony of the third degree, meaning that person was looking at a prison sentence of anywhere from 9 months up to 36 months in prison, and there would be a presumption for prison. I don't think it's mandatory prison because it's weed. If it was meth, it's mandatory. If it's coke, it's mandatory. But for weed, I don't think it's mandatory at the third degree level. I forget off the top of my head. But I've also never had anybody ever get caught with that much weed before, ever. So, and if they did get caught with that much weed, they also got caught with, actually, I've had people get caught with that much weed, but they also got caught with like 65 grams of crystal meth, or they got caught with like a half a pound of coke, or basically like this much, enough fentanyl to fill this cup. So there were bigger problems. Detectives also additionally located a small colorless plastic cylinder with a label stating Afroman and high-grade cannabis that also contained a green leafy substance. A field test was conducted on the green leafy substance, which did indicate the presence of THC. CI number 1 stated that he or she was holding the marijuana for Afroman. So we don't know about how the CI got arrested, how anything happened here, because that's not been provided. That on August 21st, and this is interesting because they talk about this as they go get the warrant. Confidential informant number 1 stated she has known Afroman. Now this is sloppy. That really tells Afroman who this is. They should have said they. You use pronouns that don't disclose who they are. Working for Afroman or Fro, and you have to be careful if Fro is a nickname only they use, or it's only a limited number of people. For approximately 10 years, where she originally started working as his personal assistant. CI number 1 continued to state she had routinely traveled in the U.S. with Afroman to concerts and marijuana dispensaries where they would obtain large amounts of marijuana to be transported back to Adams County, Ohio. CI number 1 further stated she and Afroman have been intimate for approximately 8 years, where he or she, being confidential source number 1, visited the farmhouse residence. CI said that during these last 8 years, she has consistently observed large amounts of money and marijuana at Afroman's residence. Okay. So, yeah, this is a big deal. The police are claiming that Afroman stepping on his wife. Because he's got a wife and kids at his house. And this personal assistant comes over and they, he dips the pen in some Company ink. Police search his house, found nothing, correct? Yes. Nothing. Haley says, God, I've been on Sean's screen for a while. Well, yeah. Do I have a corkscrew duck penis yet? No. Say, I only deal with the baby criminals. Well, I don't think I've had anybody with that much. I think I've had people with, like, guy with a pound before. Like I said, usually they've got bigger issues, like the 50 grams of crystal meth, which is a nice chunk, or had a guy once with a softball-sized piece of meth. So, now read chat, take you out of the corner. I try to read around here. Zaven, yes, he had Afro. They claim he had an extension. Oh, I'm not gonna sing right now. We'll sing later. Yeah, and 10K, does Afroman's wife know about the CI? Because now that this information's out there, is this true information? Because if the cops are fucking lying, this could destroy his marriage. So who knows? Remember, cops lie all the fucking time. I've seen them lie in search warrants. They're like, oh, I didn't lie, I was my bad. The CI further stated Afroman has a basement referred to as the dungeon, in which he, being Afroman, keeps women locked in, forcing them to urinate and defecate in a bucket as punishment for upsetting or disobeying him. I'm sure that, if he has a basement, I'm sure they found no evidence of any of that at all. And I really hope his basement is fully furnished, because that would be really bad for everything here. Which means that the CI's fucking lied about a lot of things, and hopefully the cops take it out on the liar. CI number 1 further stated, and actually, can you guys read this from here? Yeah, you guys can read. Yes, Afroman invites Fixman over. Yes. Yes, Afroman, I shall have a zigzag with you. I wish not to partake in the Colt 45. Yes, but your black dick, you can use it. My friend here, Janelle, loves black dick. CI stated that she was at Afroman's house approximately 1 month ago, where she, being CI number 1, observed a female known as Joe exiting the dungeon. Joe? Does that mean our Joe? Joe, what were you doing at Afroman's house? CI described Joe as a short, dark-haired, possibly Hispanic woman. CI number 1 also indicated she believes Joe is from California, although Afroman has paid confidential informant's estranged husband to pick Joe up in Mississippi. CI's admitted that they've engaged in human trafficking now. That's a Mann Act violation. That is a conspiracy to commit the Mann Act, violate the Mann Act. Interstate trafficking of women for sex. That's a federal crime. And notice what hasn't happened to Afroman. There are no Fed charges come after him. So what the fuck is going on here? I mean, this right here is very serious. That is a super serious thing. That's our guys. Like, that's R. Kelly shit. Yeah, this whole thing up here about peeing and pooping in a bucket. Yeah, R. Kelly. Ha, 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 ha. This is real R. Kelly stuff. This is why R. Kelly's going away forever and never getting out. And he'll die in prison. This shit right here. This is not good. Like, how, like, they aren't charging him with trafficking. There was no federal involved. They learned about federal human trafficking and the feds weren't involved in that raid. That to me reeks of bullshit. Alpha Fox says, yes, a pro tip. Intrastate trafficking, yes. Yes, traffic only in Ohio. Make sure your victims live where you live. Yes. Yes, you will shit in the bucket. Yes, Joe dug the tunnels. He dug Afroman's rape tunnels. Yes, and Joe, Mandy knew it. It's all coming together. Mandy will still be vindicated. Oh, I'm serious though. This is a big problem. Yes, are there potbelly goblins hobbling around? You know, cutting up eating babies alive and selling their body parts? Yeah. Yes. Yes. This is there's a problem here with how this is set up. The police are admitting they have evidence of some serious fucking crimes. And they did their little hillbilly raid on their own. Affiant further states, CI indicated he utilizes armed security at all times, stating he has some old rapper from LA doing it. He stated there's a guard shack on the west side of the residence where security cameras are monitored. Guess what they didn't find, it looks like? A fucking armed guard! Affiant further states that the CI accurately described the exterior of the property. Okay, I mean, we're gonna do something here. Accurately describing the property. I'm sure I can accurately describe the property too using Google fucking Maps. I'm sure it's not that fucking hard. Because let's check. I'm sure it's not hard, chat. We could probably do this here if it loads up. Oh, and look. 1299 Russellville Road in Winchester, Ohio. And guess what? It's a house with a green roof with some outbuildings. And then a bunch of outbuildings that are alongside of it. And then look what's there. A wooden fence. Oh my God. How could you have figured this out? Although, God, if you didn't realize it, apparently Google doesn't drive the Google van down here because I can't get a... there's no street view of this place. But if you guys were wondering where the hell this is, I mean, this is way out in the middle of nowhere in Ohio. So, but yeah, look at that. I can accurately describe his property. Oh my God. Further stating the entire upstairs of the primary residence is Afroman's bedroom. But how do you know? I don't think there was any proof of that. Further stated that Afroman has multiple mini garages. Yes, we saw that. I can tell you that too. Which are utilized to store marijuana. You didn't find any. In Afroman's brand of malt liquor, Cold Frody 5. Well, are you worried about him doing liquor violations? Because I'm assuming that's legally done. But guess what they didn't find? They didn't find any weed. They didn't find proof of any weed. Confidential informant number 1 also indicated that Afroman has a large metal building behind the residence where he stores cars. Okay. Yeah, there was a big barn in the back. That she and her husband had built a fitness room of the building, which has a false wall. Okay, well, where's the false wall? It didn't look like they found it. Afroman uses the false wall to store marijuana and money. I hope they fucking nailed her to the wall for lying. She said she hasn't been there approximately 1 month due to Afroman releasing a video depicting him urinating on Tasha Chamberlain's head. CI indicated before the incident she would visit the residence on a daily basis and did so for nearly 8 years. She further stated she would observe the aforementioned activity at the residence every visit. So it just all happened to disappear in the last month. That's the problem. The rap guy from LA, Afroman's like, get the fuck out of here, bro. Get back to LA. Hit the bricks. You know, all the secret passages, all the secret tunnels. Afroman like grabs his phone and he's like, Joe, listen, Joe, you got to get rid of it. No more Jew tunnels. Come back and fill them up. He's like, I don't know, get a Jew concrete contractor. We're filling them up now. Shut it down, Joe. Like, what is it? What the fuck? How do you believe all this shit? Unless you're trying to be malicious or you're fucking stupid. So they request a search warrant to be granted for 1299 Russellville Road to further investigate the aforementioned activity described in the affidavit. Sergeant Brian Newland. I'm surprised he can spell. And subscribed in my presence the 21st day of October, 2022. So return the search warrant. So here we go. What did they get when they return? So the return, they leave the return there for you to tell you what they took. $4,390 located in a jacket pocket. $641 located on a shelf. In the jacket pocket. Okay. Glass jar with white lid containing green leafy vegetation. Oh, they did. It looks like they found a little bit of weed. Just a little bit of weed. Afroman smoked it all. Vince McMahon showed up with Afroman. They're like, yes, more weed, more weed, Afroman. We shall zig of the zags. Yes. I shall name this blunt Lesnar. Allow me to be blunt with you, Joseph. 2 sets of scales and a black container with miscellaneous drug paraphernalia. A glass marijuana, a dab, a smoking pipe. Oh no. Oh no. Oh, a lidless plastic jar containing THC wax, more dab. Colorless plastic jar with white lid containing THC wax, a dab, and a grinder. Oh, see a lot of misdemeanor level offenses here. And then they didn't charge him with anything. The statute of limitations for a misdemeanor is 2 years in Ohio, so clock's ticking, motherfuckers. And I would argue at this point that, you know, we're coming up. We're coming up on it. So here is the house in the body cam. Here's some more body cam footage. The stills, which, hold on here. Can we like, how do we rotate? No, how do I rotate? Rotate clockwise. No, counterclockwise. There we go, rotate. Look at him, they're like, he got a better lawnmower than we do, that's colored feller. Oh, they're looking around. Yup, these are sheds. Where's all this weed? This might be pound cake here. They're walking around. Oh, this is his house. There's the door. F in the chats, boys. The door tried to do its job. It held out. He fought the law, and the law won. So that happens. Like the cops thought of Grindr, yes. Haley says, is that a rifle? Yeah, because he's a drug dealer. He's a super heckin' serious evil drug dealer. And they know that guns are quite used, and there were armed guards there, and heckin' it was going to be so scared. Oh, more pound cake. Yes, yes. Yes, Joseph, I would like a piece of the pound cake. Yes, more pound cake. Wonder if the interview of the CI was recorded. It would be interesting if it's disclosed in discovery. It's probably going to be recorded because that CI sold it all out as part of its own criminal case. So it was certainly recorded as part of that criminal matter. It's going to be very interesting to see what happens there. Now there was one more response to that. So the plaintiffs filed an answer to the counterclaim, and that's how this works. I sue Legal Vices. He answers my claims, but then he serves me the counterclaim. I have to answer those back where I'm in default. So the plaintiffs answered back. They went holla back, youngin', whoop whoop, to be cringe about it, just a bit. I'm sure you guys just said boo, and that's okay. It's actually a lot shorter here, but I'm curious to see what you guys are thinking right now anyway. If you cough that hard, you could damage a lung. Yes. Digital scales were in the kitchen. Yeah, we don't know where they were found. Haley said, is weed legal in Ohio? Yes, now it is, but at that time it was not. Do they note the money they took? Yeah, if we go back through this real quick. Hold on here. Yeah, they talk about the money in the return because they do an inventory. And part of the inventory is you have to lay out what you've done. So they talk about all the money they took. Now, obviously, Afroman's claiming there was $400 more here, you fuckers stole. They're like, nope, that was just an accounting error. It was actually $400 less. Sorry, Afroman. You understand. So I hope you understood there, Ashley. Haley, they did claim that. Is DMT legal in Ohio? I don't think so. Kimbo says hanging out with a coked up Vince in a basement could be on the same level as Aqua Teen Hunger Force. Oh, that would be great. That would be great. Oh. Zero Fuck says, I only exhale when I'm about to pass out. No. You're 100% door pilled, yes. Rip door, F, F, F. Joe Loy says, lol. It's like, you're gonna, that door stood up to the government. Participation trophy wife says, huh, today I learned my stash is way more impressive than Afroman's. Well, I'm assuming, he, at times is probably better than others. Kimbo's saying, imagine you're trying to get high and Vince is ruining it by constantly shitting on some girl in the head's corner. Yes. It's like, Vince, you can use the bucket, man. He's like, no, it must go in her hair. She can use the bucket. But yeah, there's no shit buckets. Apparently, there's no footage of a dungeon either. So, Hubbleson says the informant probably stole the stash. I bet. So here is the answer for the plaintiffs. So they have to remember, it's like tennis. You have to lob back a ball. If you don't, well, then you're in default and they're considered true. So they deny each and every allegation set forth in the counterclaim unless they specifically admit it. They restate their allegations set forth in their amended complaint and restate their answers to the counterclaim as set forth. They deny the allegations. They admit the allegations contained in paragraph 57. They deny the allegations contained in paragraph 58. Paragraph 59 of the counterclaim references Exhibit A, which speaks for itself. Yeah. Exhibit A is Exhibit A. We're not objecting to that. For that reason, the plaintiffs deny the allegations contained in paragraph 59. Plaintiffs deny the allegations contained in paragraph 60 of the counterclaim. They deny the allegations in paragraph 61. Paragraph 62 references Exhibit B, which appears to be a screenshot image of the body cameras to speak for itself. For that reason, they're denying the allegations, but they're saying the pictures are what they are. Because if they denied it fully, flat out denied paragraph 62, they're in trouble because now they're saying, are you saying those pictures aren't real or what they are? Well, no, they're saying, look, those, and you can do this. You can parse things out. You can say, yes, this part's true. We deny the second part. You can break that down. You can get very particular with that. Paragraph 63 is a body-worn camera, and they say, yeah, the picture is the picture, but we're denying the allegations contained in it. Okay. 64 does, again, the body-worn camera, and they do a again, to the extent the allegations contained in paragraph 64 reference material not attached to the counterclaim, such material speaks for itself. For that reason, they're denying the allegations. Deny the allegations in paragraph 65. They admit Foreman has not been criminally charged. Sorry, hold on, guys. See what's up. And it would be paragraphs, they say for one of knowledge, we have no idea. And they make more comments here that they deny the allegations, but if there's a physical item, they're saying that is what it is. If you guys are wondering, New Albany, Ohio is outside of Columbus. Paragraph 68 contains legal conclusions which no response is required. If the court does require it, because if you say I'm not going to respond to that, the other party may go to the court and say no, they have to answer it, and the court may force you to answer it. So you're saying if you are going to make me say something, we're saying it's bullshit. It's a legal conclusion. Well, let's go back to that. What are they arguing here in 68 and 69? Let's paragraph 68 is paragraph 68. Oh god, we got to go back far because there's a lot of them. So, for example, here, paragraph 68 is saying the plaintiffs in this case are employees of the sheriff's office and they have qualified immunity. Okay, well, it's a legal conclusion. That's just stating the law. So all they're saying is we're not going to comment. We deny all the allegations. But if you're making us answer a response, we'll say we deny all the allegations contained in it. Now, a legal conclusion is not an allegation. They do it again, and they have to go back through. And there were, I mean, guys, there were how many paragraphs in the counterclaim here? There were like 160 some. So they have to go through this whole freaking thing. They might deny allegations. They might reinstate their answers to certain parts of it. You know, they deny it because for want of knowledge. We have no idea. We don't know. They might say this paragraph does not allege facts requiring a response, but if we're forced to answer it, we deny it. You know, there's more legal conclusions, and this is kind of there. There's an issue about the rules, paragraph 121. This is talking about the parts where it mentions the Ohio Rules of Civil Procedure. And they're going to say, look, the rules are the rules. We're not going to argue and talk about them. To the extent you're making us require an answer, if there's an allegation there, we deny it. But they don't consider it to be an allegation. It's just a legal conclusion. And I mean, look, it goes on and on and on and on and on and on and on. Now, notice what they say. You know, oh, you failed to state a claim upon which relief can be granted. The defense may have failed to exhaust their administrative, contractual, and or statutory remedies. That's an affirmative defense there, and this is their second affirmative defense. The third defense. The defendant's claims may be barred whole or in part by prior, subsequent, intervening, or superseding acts, omissions, or causes, and or by the acts or omissions of individuals or entities with whom plaintiff had no right or control over. Okay. Defendant's claims are barred by failure to join necessary and indispensable parties. Well, like who? You kind of have to say who those parties are at some point. Plaintiffs acted in good faith in accordance with the law. I doubt that. Plaintiffs affirmatively deny the plaintiffs have breached any duty they owed to the defendants. Yeah, I disagree. The actions here met the test of reasonableness in all fashions, and as a result thereof, no actions for violations of any duty are maintainable. His own conduct bars a claim for relief. That goes back to the idea of like unclean hands. Your conduct is barring you from getting a relief here. Defendants may be barred by a failure to mitigate damages, and you're expected to mitigate damages. So, for example, if your neighbor is using like a bucket truck and they accidentally punch a hole through your roof, okay, well, you need to fix it at some point. You can't just leave the hole in your roof sit for a year till the case is over. Because a year of like the rain and the snow and well, that's going to destroy your whole house. Well, now you don't get to come back and say, Your Honor, I need to fix my whole house now. You have to mitigate damages. So you have to I have to patch the roof. Now you're entitled to get repaid for what you spent. But you can't just let damages build. If you can stop them, you're expected to stop them. Now you get compensated for the mitigation. Defendant's claims may be barred whole or in part by the doctrine of consent. Maybe there's an issue of, well, did his wife let him in? I don't know. The claims may be barred by the statute of limitations. They're not, but you argue everything. Remember, if you argue it all, it's all out there on the field. You can use it. The doctrines of laches, waiver, and or estoppel. Defendant's claims may be barred whole or in part by a lack of capacity and or standing to seek the relief for which they pray because this matter is non-justiciable. The counterclaim fails to state sufficient facts to entitle defendants to any award of damages or injunctive relief. I'd argue, guys, this is a far better way to list out your defenses, and this is a way I would do it. I would list them all out, not just say, well, anything that's there. You could do that, but you could list them all out and then you do the catch-all. I think it's a far better way of doing it. To the extent they seek punitive damages, The claims cannot be sustained for conduct if the plaintiffs did not show malicious intent or complete indifference or conscious disregard for safety. Well, you run through the house with guns, although they'd argue that's part of our job. The defendants seek punitive damage or exemplary damages against plaintiffs, and award of those types is contrary to the U.S. and Ohio constitutions, as well as federal and state statutes, and is therefore not available. This is, once again, you should probably bust out a citation, but you're just doing blanket defenses now. You could bring these up at a summary judgment motion later and flesh them out if you want. The defendants assume the risk of the injuries and damages. Yes, you assume the risk the cops are going to raid your house. This isn't really a good one, but you, like I said, you put it all down. The 18th defense, contributory comparative negligence. Plaintiffs are entitled to immunity, including statutory, absolute, and qualified, and immunity from all damages. The plaintiffs are expressly subject to, barred, or limited by the provisions of Ohio's political subdivision tort immunity statute. The plaintiffs are entitled to set off of damages or limitation of damages. Meaning that, let's say they find out that, it just determined that Afroman caused like $10,000 worth of damages from the defamation total. But it turns out they caused $10,000 of damages when they tore his house apart and they didn't have the right to. What happens there is set off, where the court goes, okay, well, you know what? You guys both go your separate ways. They cancel out. Or let's say Afroman had $11,000. Okay, well, now you only have $1,000 that you can collect on. The defendants claim the plaintiffs are expressly subject to and barred by the doctrine of qualified immunity. Plaintiffs entitled to indemnification, contractual indemnity, and contribution pursuant to statute. Yes, I think at this point they're going to claim you have to bring in the sheriff's department. That the county, Adams County, has not been enlisted as a party, a necessary party. Sure. But are they individuals or are they operating as county employees? Because if they're government employees, all this bullshit about individual personas goes out the window. And I think that's a problem. So the court lacks jurisdiction to hear the counterclaims. And that's just you might say, well, that's a Darrell Brooks argument, but you fucking make it. You make the argument. You shoot your shot. If anything's relating to 42 USC 1983, a state court lacks jurisdiction, which the plaintiffs here got to give notice they intend to rely upon and utilize any other affirmative defenses which might become available or apparent during the course of discovery, and hereby reserve the right to amend this answer to assert such defenses. And they want a jury demand on all the claims. And that's what happens there. So that's their response. Russell says, like trench warfare. Yeah, a lot of back and forth. Best format I've ever seen in response was Q&A style. The defendant copied a question in bold, then submitted the response below the question. It was long, but it's way easier to follow. Yeah, but that's... Yeah. Yes, he gave my Gina Carano review an S tier. Yes, I did. Especially once I got to the end and it was really clear. I think she's got some justiciable claims. I think she can at least get to discovery. Is she going to get to trial? Probably not. Is it going to survive summary judgment? Probably not. I don't know if it gets that far. But it's going to get to discovery. So we'll see what happens. Yeah, this is pretty standard, but if you guys haven't seen these before, this is what the back and forth looks like. Now, now from there, because this was filed on, oh God, it's got to load, November 22nd, 2023. Okay. From there, we're going to go to the actual docket. See, I want you guys to see what happened from there. Okay. So we're at November 22nd. The plaintiff's answer to defendant's counterclaim right here. Okay. This bad boy. That's where we're at. Okay. So The attorney for the defendants on December 6th filed a motion to leave to file amended complaints. Because you have the right, you have one chance to amend your complaint. All right. The plaintiffs on the 15th filed a memorandum in opposition to amend the complaint and amend the counterclaim. And that's what we're going to look at here. Because this motion to leave, you're asking for motion to leave because you don't have the right to do it on your own. So what did the plaintiffs say? Or what did the police say in response to shut this down? Well, that becomes an issue of, what happened? And from there, it gets a little more interesting because now we're getting the part where I'm like, things are getting a little rough. So this was filed December 15th, and this is their response, and it's very short. Obviously, they're going to oppose this. If you're seeking leave, the other party generally doesn't allow you. So the plaintiffs only oppose defendants' request to amend the counterclaims. Any opposition of plaintiffs to defendants' request to amend their answer will be filed separately. The first amended complaint was filed on May 10th. Defendants filed their answer counterclaim on October 27, 2023. After the motions to dismiss and the summary judgment, the 12B6 motions, were dead. Plaintiffs timely filed their answer to the counterclaim on November 22nd. The Ohio Rules of Civil Procedure permit parties to amend as a right 28 days after service of response and pleading. So notice, from 28 days after you serve a pleading. So the answer and counterclaim was on October 27th. You have 28 days from that point to serve an additional amended complaint. Okay? Or in this case, a counterclaim. They have 28 days to amend this. All right? They have 28 days from this day. Well, guess what happened? On December 6th is not 28 days later. It's after 28 days. Without any explanation, the defendants are seeking leave of the court to amend both their answer and counterclaims. Their request is unsupported by law or any specific facts, and this is an issue. They haven't said why they want to do it, and the law doesn't support it, and the rules of procedure don't support it. So now that's not good. Courts will freely grant leave to amend where justice requires, but they've offered no justification for the request to amend. Typically, when a party seeks leave to amend their claims, they attach a proposed amended complaint and seek leave instanter. Meaning, here's what I want to do, Judge. Will you grant this leave? Yes. Okay. Boom. And I seek leave to file this immediately. That's what instanter means. Instantly. Otherwise, let's say there's a deadline. You have to file something 7 days before it's due. Like in Ohio, for example, guardian ad litems in domestic cases and children's services cases are supposed to provide the report when they're required 7 days before the hearing. But there's some guardian ad litems that don't get it done until like 2 or 3 days before, the day before. Some of them have filed it the day of. So they file a motion to leave to file instanter. And the court says, yeah, you could file it instantly. It's considered in now. It's all good. Parties typically describe the amendments they seek to make. However, the defendants did not attach a proposed amended answer or counterclaim. The defendants also did not describe what, if any, claims would be added, modified, or removed, or what would be added or removed, or whether parties would be added. The defendants merely refer to new causes of action that they must pursue, devoid of any reasoning behind what may be sought or why they were not pursued originally. Given the lack of information, they can't assess whether the amendments would be redundant, futile, or serve to delay, or would prejudice themselves. So they're saying we can't do anything about it. When the party has not made the showing of support, the court can deny it to amend the pleading outside the window. And they need to ensure that it's not a delaying tactic or would prejudice the other party. They didn't show anything. Now, I will admit I did actually read ahead and read this one because I was trying to figure out what happened. So, given the complete lack of information regarding the request to amend the counterclaims, they're saying that the court deny it. Well, what happened? When we go back to this, so they filed their memorandum in opposition leave. Okay, well, and then what happened? There was a motion to withdraw. Well, what's the motion to withdraw? Motion to withdraw is counsel. So Bruce Rivers and Tyler Cantrell. Tyler is one of the local attorneys, and Bruce Rivers is obviously Bruce Rivers, criminal lawyer, is asking to take off. He's like, hey, judge, can I bounce? You lied to us on that motion. I didn't read the rest of them new. I read the rest of those new. So, Wooksy says a twig was granted leave. Yes. So Bruce Rivers is probably very old. No, he's not old. Oh, if he's using an AOL email, yeah, that would be fair enough. But yeah, so yep, he's it's him out in Minneapolis, and yeah, serving on all the parties. And this is also here when you get to a motion to withdraw. Do the other parties on your side agree? Do the other attorneys understand, and have they signed it? So they already got Afroman set up with a new attorney. David Osborne, and his number is 0096879. He's a younger buck because mine starts with 91. So he's a younger dude. Maybe I can reach out to him. Maybe he'll talk to me a little bit. But he's a younger buck. Got less than 10 years of practice under his belt. Doesn't mean anything because if it's a bullshit case, anybody can run it. Afroman has signed it. So if you want Affirmative signature, there you go. His autograph. And then Hungry Hustler Records, signed by Afroman. So he's signed off on this. There were a couple questions, like people accidentally thought one of the amicus attorneys was pro hoc vice for the defendant. There were some issues and concerns there. Yeah, that was yeah. So on the 27th, the attorney then filed his response to plaintiff's memorandum in opposition and his amend counterclaims and stanter. So all that stuff they said you should do, he did. But he also did it kind of late, like after Christmas. They also filed a motion to strike the plaintiff's first amended complaint. Now, this is just very quick. And notice this is a different format of captioning. So it's clear this is a different attorney now. David Osborne, DJ Osborne Jr., is calling the shots. And yeah, I have my own caption. I do mine a different way too. So you can tell the two attorneys involved. And they request the court strike the first complaint as filed out of time and without permission of the court. And they point out like the same rules. You guys have 28 days. Guess what you didn't do within 28 days? You didn't seek leave. So the 28-day deadline would have been to amend would have started on March 20th, giving the plaintiff till April 17th or 18th, depending on if you count the day the defendants were served. And I think the court would probably not give it to them. So the plaintiff, they filed their complaint on May 10th, almost 2 months after the service of the complaint to the defendants. The 28-day deadline passed and they didn't seek leave. And that's a problem for them. So there was a motion to strike the entire thing. He's hitting back at him really hard. I give him credit. Apparently, nobody noticed that before, which I'm a little disappointed in. So there was another motion that he filed, and he filed the, and this is where he talks about the instanter issue. Oh, nope, get that out of the way. And let's see what he says about that. So it's only 5 pages, and we're just going to catch up here, guys, on all this stuff. So he's saying that through their lead attorney, as the case has progressed, defendants have employed a new counsel. So they're saying, hey, look, I'm a new attorney on here. I'm trying to catch this up and put out all the fires. Defendants have employed a new local counsel after discussions with attorney Bruce Rivers and Tyler Cantrell, have decided to withdraw from the case and filed a motion from December 19th. And all parties got a notice for the new lead attorney. This created issue of service as Attorney Osborne was not served copies of the memorandum in opposition to leave to amend, nor the notice of appearance for attorney Helen K. Sudhoff, who is one of the attorneys who's taken over for the cops. A notice of appearance is how you tell other parties, guess what, guys, I'm involved. You serve it on all the parties so they know, and that way it's known for the record. I now represent them. All matters, please send to me. Additionally, the lead attorney filed the motion to leave to amend and thus should have been served a copy of the memorandum of notice. Yet with notice given by plaintiffs, the lead attorney, by searching court records, found the filings and responded on the same day they were found. While the lead attorney found these filings on December 27th, the deadline to respond was December 22nd. Thus, defendant's lead attorney, while not being served, responded to the plaintiff's memorandum as soon as he learned of the filing. And this is why you serve parties, because he's like, I didn't know this existed until I found it. I found it. I'm serving it right now. I'm serving it that day. You know, Judge, you got to cut me a break here. They never sent it to me. And even though it was clearly me, that was known. And he asked for Prey to grant leave their first amended counterclaim. And the memorandum in support is attached and incorporated by reference. And here's the memorandum of support. And this is how you could do it. You just spit it out here on the bottom. And they talk about, here's the factual issues, though, because they talk about seeking leave of court. Shall be freely given. Okay. Plaintiff filed their first amended complaint almost 2 months later. It should be noted the plaintiff filed their complaint outside of time as well. Well, that's saying somebody else already got that isn't the best argument, but you do make it if you can. A motion to strike was filed simultaneously with this response. After a series of motions was ruled on, the defense filed an answer and counterclaim in October. In November, he's referring to himself in the third person, filed his notice of appearance. After reviewing the case, he determined there should be an amendment to the counterclaim of the defendants. As 28 days had passed, they must seek leave of the court. It should be noted the plaintiffs didn't follow this process. Well, you're only going to get so far blaming the other guy and calling out that they were wrong. The plaintiff requests more information to be supplied, and the defendants seek to avoid not taking the word of the attorney for the defendants that it would be in the interest of justice to litigate all claims that could come out of the same incident. And he's saying, what, is my word not good enough? The defendants seek to add claims against for dereliction of duty, invasion of privacy, theft, and conspiracy. These claims all stem from the same actions and are only an extension of the claims already pled. So once again, like the conversion and the trespass to chattels, these are all additional things that play off of stuff they've already done. It's in the interest of justice these claims be added now, so all claims around the search of the home be litigated at one time. After all, it makes no sense to claim these claims could not be added, yet a new case could be filed against the same plaintiffs to allow litigation to continue. And that's fair. Fine, we'll file these separately. That would be really dumb. He says, I've just filed this instanter, so I've just learned of the plaintiff's filing. I've filed it instantly. And they pray the court will allow amend the claim. And he signs it. And he's sending it to everybody. The attorneys, the amici, Bruce Rivers, the old attorney, new attorney, and new attorney. The new attorneys for the cops as well. He sent it to everybody. Everybody. I will give him credit, man. He got that shit out quick. Although it's interesting. I can tell he went to Ohio Northern University because that's onu.edu. He's still using his law school email address, which I'm surprised it's still open. Normally they shut those down after a while. But yes, his email is onu.edu. I'm sure he went to Ohio Northern. Oh, fuck this. God damn it. This. It's not scrolling. Fucking StreamYard. Okay. Fucking StreamYard. Okay, so there's a new attorney coming in saying I'm new, guys. Let me help out here. I was never notified of I was never served, even though you told me. So what they're going to do, you guys fucked up. Well, that's not a good argument, but it's an argument you make. And they want more time. And he says, well, I've got the ability to fix this. They all come out of the same claim. You guys can catch up. It's not hard. And you guys can read along here. And this guy knocked it out real quick. But yes, here's his email address. That is a Ohio Northern University, which they do have a law school. It's weird. You wouldn't think they would, but they do. So, Bruce Rivers, they got withdrawn. And the court allows them to withdraw. The last thing we have, and we get to this point because there's nothing else after this that you can see, is the court filed a motion. I'm sorry, the court made its ruling. And here we go. This causes before the court on two motions. A motion by Bruce Rivers and Tyler Cantrell to leave, and a motion for captured leave to file by new counsel. As to the motion by the new counsel, DJ Osborne, leave to file an amended answer a counterclaim. You may amend your pleading once as a matter of course within 28 days. After serving it, the motion in this case is made after 28 days have expired. Outside the 28 days, it may be amended with the consent of the other party, which is lacking. Leave may be granted when justice so requires. Once again, he did not attach a copy of his proposed amendment and has not otherwise given a reason why an amendment is necessary. Under these circumstances, the court is unable to find that justice so requires with respect to the request. If counsel suggesting that he is merely new to the case means that there is good cause to be shown, the court's not allowing him. That's not good enough. For these reasons, the motion to leave to file an amended answer is not well taken and it's overruled. But Bruce Rivers is out. They get to leave. Now, why do I make that important? Because there's nothing else here. There's a nunc-pro-tunc entry, meaning they had to correct a clerical error stating that one of the ACLU lawyers was not one of the co-counsel for the defendant. So we don't have anything new. There's a copy of the decision granting motion of Bruce Rivers to withdraw. And this is a hearing is scheduled on March 11th at 9 a.m. It's a telephone pretrial hearing. And there was just now a hearing done this past week at 8:30, a telephone pretrial scheduling. And then notice of, because Bruce Rivers left, there's a notice that he's automatically now, his pro hoc vitae status is gone. It's poof, it's done. It's automatically excluded. If Bruce Rivers wants to come back into Ohio, he has to reapply again. But he's probably not going to, unless he's got another case at some point. So that is the status of it. Now, if I was Osborne, would I have refiled it? Then fuck it, I'll stamp it, refiling it with the court. I would ask for leave to, reconsideration. Sure, the court may grant that. They probably won't, but it's too late. Now, the motion to strike, because the stuff is out of 28 days for the plaintiffs, that has not been ruled on. And I don't know when the court's going to rule on that. So unless the court dismissed it outright, but I don't see it doing that. So that is where Afroman currently is. He's going to have to go to discovery. Now for then, is that correct? I'm not. Yeah, I mean it makes sense. So it could just be a pass-through address. Yeah, but just put down your own address. I mean, shit, get an Outlook. I mean, you know how many attorneys use Gmail? Pretty much most attorneys use Gmail. Most practicing attorneys use Gmail. So I was doing that all from memory. Yeah. So whoever scanned a document did an awful job. Make it straight. Yeah, well. So is it going to go to trial? No. No. No, it's not going to go to trial yet. We have discovery. So it's probably going to get to the discovery phase. Although, if the motion to strike is granted in that 28-day rule, the court actually enforces it, that amended complaint the plaintiffs allege is gone. Now, if regardless, they probably still have enough, the court would say those initial, the 1, 2, 3, 4, and 5 claims, okay, counts 1 and 2 are still gone, but the defamation, the false light, and the invasion of privacy will still survive. So what happens then? Well, now we have scheduling for discovery, and that's what some of those pretrials are going to be. What's the discovery timelines? When is it going to be completed by? What are we looking at? Are we going to do depositions? Are we doing interrogatories? Are there going to be requests of admissions? Are there going to be requests for admissions? We don't know yet. There's going to be some sort of discovery. Is there going to be exchanges of discovery, requests for discovery, discovery demands? Notices of deposition. Are they going to be videotaped depositions? Are they going to be just with the court reporter depositions? Where are we going to do them? How are we going to do them? What's all this going on? So it'll be interesting. No, we are not close to trial. Trial is a million years away at this point. Discovery has not even started. So did Bruce do anything? I think Bruce was involved in some of the drafting of stuff that was going on, but I don't know what he did. I mean, he probably worked on stuff, and he does know rappers. He's represented rappers. I bet he had some affiliation with Afroman, and then he thought like, oh, we can knock this out once the court's not biting. He probably told Afroman like, you're probably cheaper to use local counsel because I'm going to cost you an arm and a leg, and good luck. He's like, I still think he can win. I'm sure that's probably what happened. Hubbleson said he reacted. Yeah. Do I use an ALL Boomer account? No. Is my browser Netscape? No. Ian Miles Chung got charged with sedition in Malaysia. Well, couldn't happen to a nicer guy. Jim is saying Gina Carano getting Discovery will force a settlement from Disney. They might try to hold out and see what they can get out of her first. But I think she survives and gets to Discovery. Don't diss the original CLR. I'm not dissing him. Eric saying Bruce Rivers is probably very old. Oh, he's far from old. I mean, he's older than me. But no, the dude's on top of his game and shit. He's fucking rocking it. I wish I was as busy as Bruce Rivers is. Alpha says, yes, when it comes to amending complaints, one chance by right, / rules of procedure and no more, or is it +1 or 1 plus discretionary? Yes. It's all discretionary unless, like, let's say the cops were like, fine, amend it. You could amend it any time. Or the judge says, okay, I'll allow you to do it. It all depends. Yes, you only get one mulligan, and you've got 28 days to do that mulligan. Without question. You could do it and nobody can stop you. That's the neat part. You have 28 days of your own accord to file that amended complaint, and nobody can stop you from doing it. Now, they could try to attack it and do stuff, sure, but they can't say you're not allowed to do it. Chaucer is saying, I understand the purpose behind qualified immunity. It should be true in some cases, but when filing an in-person civil rights become an anonymous tip, it's dystopian. Qualified immunity doesn't need to exist. Cops survived beforehand. They were surviving before him. There wasn't a rash of them getting sued left and right. And if they are, then fuck. They get, deal with it. I don't fucking care. That's fucking their problem. Jim is saying the statement about stealing money in the evidence room might make it pass a motion to dismiss. Yeah, and I think those are going to be some issues. Like, how do you know that? Where have you heard this? And it'll be like, I've heard from people in town he was a drug addict. And there might be something there. I doubt he's just making all that up. And if he is, well, he's a little stupid about it. But we'll see. I will point out, like, all the police out there, Lickum Lisa, this lieutenant the sergeant who's mad, Officer Poundcake, you guys are little bitch-made faggots for doing this. You are fucking cowards. Absolute fucking cowards. Just go the fuck home. This lawsuit's bullshit, and they should be called out for that. Iman Rezu says, more S-tier lawyering. I understand that reference. Thank you. So, all right, guys, that's it for tonight. We're all caught up. All the super chats are caught up. Guys, I can't tell if it says Rumble's not working for me. So if you're over there on Rumble, hi. But Rumble says you're dead, so I don't know. Chaucer's saying, do judges typically like being told they have no jurisdiction by the police? Oh, you mean that whole saying you have no jurisdiction to hear this case? Well, no, they're just saying that's a federal course of action. That's not the jurisdiction of an Ohio court. That's all they're saying there. So that's all they were getting at. I think that's what you're asking. You still have a Hotmail address. Cool. Stacey says, let's all come to Ohio and commit crimes. I mean, if you do, that's fine. Just remember, I'm not the Salvation Army. I don't work for free. So be ready for that. Josh Peckle says, thank you to whomever gifted the membership. Well, I know a bunch of people have been doing it lately, so whoever did, yes, thank you very much. Very, very much. So, guys, with that said, we're all done for tonight. Yeah, Michelle Troconis, if there is a trial tomorrow, we'll definitely do that. Yeah, and I'm not sure what else may pop up. If there's something else to talk about tomorrow night, we will. But for now, we'll do something. This Matthew Harris thing really does happen. I'll take a look at it. Carrie, hold on. Carrie's saying, read the thing I sent you. Sent me where? Because I get a lot of things sent. All right, if it's on locals, locals is not popping up for me right now. Hold on. Yeah, I don't know which. We got a lot to talk about for Thursday night, though, guys. There's a bunch of stuff to happen. We've got the cop who heard random gunfire out of nowhere and almost killed people. And Carrie, you sent a bunch of stuff on local, so I can't see what you're talking about. We got Vosh. Looks like he's a connoisseur of cheese pizza, which, a communist who likes little kids. Who would have thought? I mean, really, who would have thought? So, Carrie, we'll talk about that report, okay? I just don't have time tonight. And then, yeah, we'll talk about Fanny's hearing. There is a lot to talk about, guys, and we will get to that. But in the meantime, have a great night. And remember, just because, well, actually, it doesn't matter because they're not guilty here. Afroman's righteous. Fuck the police. That's all I can say tonight. Fuck the Adams County Sheriff's Office. Afroman's the king.